Good afternoon, everyone. We're here for the November 19th, 2019 version of the BMZA. We thank you for coming. Ask that you turn off all your cell phones, keep talking to a minimum. If you do need to have a conversation, just please step out into the hall. As you all know, it's being recorded visually by audio. The board will vote on each case and make a decision at the end of the docket. It is a fairly interesting civics lesson if you care to stay to watch it, but otherwise you can call the BMZA office tomorrow after 9 a.m. Numbers 410-396-4301. Again, that's 410-396-4301. In any event, you'll receive your resolution in the mail within about 30 days. As always, we ask that you not do any work until your resolution is resolved by the board. And please do not do any work or build in Baltimore City without pulling the proper permits. We have some cases that are on the postponement docket. I guess I still need to call those and formally postpone them, or?
They've been already.
Okay, never mind. Forget what I said. Moving on. We have a few cases that have some opposition, and folks have been encouraged to sign in if they're here to oppose a particular matter. There are certain matters that we know that will go forward, but for the matters for which there's opposition, we'd like to offer you or afford you the opportunity to speak with the other side. We find that giving you that opportunity sometimes can resolve the last remaining issues, and maybe some consensus can be reached. I will ask for some assistance on that, Mr. Baumgartner.
Yes, Mr. Chairman, we have a resident signed in against 2019-379, 6800 Hartford Road. Mr. Hilliard in the room?
Anyone here for that matter? The applicant, who's the applicant for that?
The applicant is Chidi Mike Anyanwu.
Okay. Have you folks had an opportunity to speak regarding the issue or the differences?
Chairman, I'm here representing Arbel, which represents the North Hartford Road Community Association in this matter.
Yes, sir.
And there's nobody from that association here, and I'm not really authorized to negotiate.
Very well. Thank you.
Next case where opposition is signed in is case 2019-381, 5837 Bel Air Road, Adele El Free. All right. I'm sorry, that's sign in for. Next one, actually, no, I'm sorry, that's correct. Mr. Hilliard as well?
Yes.
Same
issue?
Got it.
All right, moving on.
And then lastly is 380, 4227 Springwood Avenue.
Okay.
Okay. Okay. Mr. Terrett?
Yes.
Okay, have you two had the opportunity to discuss the appeal or any accommodation? Correct.
I don't know this gentleman. I just got here.
Okay. Would you like to have a discussion right now? You're certainly not required to, but okay. If you want to step out the doors, I'm at the rear of the hearing room, and just if you work something out, great. If you don't, just come on back in.
Okay, thank you.
Thank you. It's too late.
Okay. So while that is happening, we'll move on to the consent cases. These are cases that we'll call for which the board has concluded that we have sufficient information to approve the appeal or grant your request. We have several on the docket. When I call your case number, please line up to my left. You'll all be sworn, and then we'll hear your particular matter. First, call the case of 2019-382, 1645 North Calhoun Street, known as 1622 North Carey Street. Next consent matter is 2019-383, 1417 Park Avenue. Then we have 2019-385, 1311 West Old Cold Spring Lane. And right behind that, Mr. Corbala, we have 2019-386, 1309 West Cold Spring Lane. And finally, we have 2019-387, 911 West Lake Avenue. All right. Yeah, well, the first one will start here and then line up to, down along this way. Welcome, everyone. Can we have all the party sworn?
I raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Great. Okay, case of 2019-382, 1645 North Calhoun Street, known as 1622 North Carey Street, presented by the Maryland Community Health Initiative, Inc. And who's here on behalf of that?
Bill Brooks and Harry Shorts.
All right. This is a request to use a portion known as 1622 North Carey Street as acupuncture and group counseling. Is that correct?
That's correct.
Okay, do we have any staff reports?
Yes, thank you. Martin French for the Baltimore City Planning Department. Planning Department has reviewed this application, noted that this property is a designated Baltimore City Historic Landmark, known as the Historic Frederick Douglass High School. Therefore, all exterior changes, including additions, demolitions, alterations, and signage, are subject to review and approval by the Commission for Historical and Architectural Preservation. The department is recommending approval of this application subject to these conditions. One, that the approved use shall be for acupuncture and group counseling only and shall not include activities or services that would otherwise be provided at a healthcare clinic. And two, that all exterior changes, including additions, demolitions, alterations, and signage, are constructed or installed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Thank you, Mr. French. Mr. Brooks, if the board were to look favorably upon your application, are those conditions acceptable to your client?
Yes, they are.
Okay, is there anything else you'd like to add to your application?
No, we were here last year for a similar zoning appeal. I'd like to thank the board for approving our appeal for 1610 North Carey Street. This is in the same block right up the street. Nothing's changed. We just want to be able to provide services at an additional location.
Very well. Well, the board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you.
Thank you.
Great day. Calling the next case, 2019-383, 1417 Park Avenue. Mr. Casper?
Yes.
Okay, this is a request to replace the existing fence with a 7-foot-high fence. Is that correct?
Correct.
All right. Do we have any staff reports?
Yes, Planning Department reviewed this application, noted that this property is within the Bolton Hill District, which is a local historic district. Therefore, an authorization to proceed is required to come from the Commission for Historical and Architectural Preservation. The applicant has been granted an authorization to proceed to erect a fence of 6 feet of height. If the board should recommend approval of this application, the department requests that this be subject to condition that new or replacement fencing authorized by the board is completed in accordance with a new authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Okay, Mr. Casper, having heard from planning, are those conditions acceptable to you?
Yes, I think I understand them. In other words, chap has to say yes.
Correct.
Yeah, okay.
Very well. Is there anything else you'd like to add?
No.
Very well. The board, having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you.
Thank you, Ms. Casper. Calling the case of 2019-385, 1311 West Old Cold Spring Lane. Mr. Carballo, this is a request to construct a 2-story, single-family, semi-detached dwelling?
Yes, sir.
All right. Do we have any staff reports for this matter?
Planning Department has no comment on this application. Thank you.
Okay. You know what? I'm going to call the second one as well. 2019-386, 1309 West Cold Spring Lane. Mr. Carballo, this is also to construct a 2-story, single-family, semi-detached dwelling. And do we have any staff reports on that, Mr.
Planning Department also has no comment on that application. Thank you.
Mr. Carballo, is there anything you'd like to add to your applications?
No, sir.
All right. Well, the board, having heard your appeal, I believe we have sufficient information to approve your appeals, plural.
All right. Thank you.
Sir. Finally, on the consent docket, 2019-387, 911 Westlake Avenue, an application brought by AB Associates and the esteemed Mr. Post with you. Good to see you, Mr. Post. There's a request to consolidate 911 and 919 Westlake Avenue, lots 001 and 001A, and use as an educational campus. Is that correct, Mr. Birchall?
That's correct.
All right. Do we have any staff reports?
Planning Department has reviewed the application and has no objection to its approval. Thank you.
Very well. Is there anything you'd like to add to the application?
Just briefly, I'm here with Jennifer Bussey, who's an attorney with Wyford Taylor, who prepared a proffer of reasons in support of the conditional use application. I'd like to give the original and some comments to the board. And as you mentioned, Chris Post, who's the headmaster of Boys Latin, this is an exciting time for Boys Latin. It's an important acquisition. It's an important property. More importantly, the school has worked since June with 7 neighborhood associations, some in the city and some in the county. And you'll see attached to the arguments a memorandum of understanding with the Poplar Hill Association with certain conditions, and a memorandum with the 6 other associations as well that deal with future proposals by Boys Latin. School's gratified that the organizations work diligently to provide that to us. We liked working with them. It's a great use, as some of you may have heard if you've read the application. We're going to use an existing building as a new dormitory for 40 students, and it's not entirely a new venture because they do have some out of state students now, but it is an exciting time. If there are any questions to the headmaster or Jen Bussey,
Okay.
otherwise we appreciate your recommendation.
All right, any questions from the board? Good. All right. Well,
Thank you very much.
we thank you for your presentation. And let me just finish the statement that the board, having heard your appeal, believe you have sufficient information to approve your appeal.
Great.
Thank you so much. Best of luck to
Thank you
you.
very much.
Looking forward to seeing you. All right. How's Matt doing?
Doing great. How about that?
Great. Good. Good guy. Ah, come on. He is one of my center class. We're classmates at VL. All right, so we're going to go on to the regular docket at this point. We're going to call a few cases that have opposition, and we will get started. Case number, go ahead. Okay, sure. Thanks. Case number 2018-452, 1743 North Washington Street. Mr. Woolman? Good afternoon, sir.
Good afternoon, Mr. Chairman.
This is a request to use the first floor as a grocery store, is that correct?
That is correct.
Okay. Swear the witness here? Oh, we have opposition on this?
She's over there. She's over there.
Oh. Oh, okay. Of course. Opposition is going to be on this side, to my right.
No, this is not opposition, this is with us.
Okay?
Yeah.
Okay, good. So you're in the right place.
Yeah. All right.
Is there opposition here?
I was looking for the president of the community association. I didn't see her. I know they submitted
Did
a
you see
letter.
it earlier today, or no?
I did not see her.
Okay,
I know they submitted a letter last night or late yesterday.
all right. Well, we'll move forward. We swear the parties?
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
And do we have any staff reports?
Yes. First, we have a letter dated November 18th, 2019, from Doris Minor Terrell, the president of the New Broadway East Community Association. She writes that her letter is written in submission in opposition to the conditional use of 1743 North Washington Street, first floor as a grocery store or a neighborhood commercial establishment, retail goods establishment. The Broadway East community has continued to experience an increase in violent crimes over the last 3 years, yet the 1700 block of North Washington has experienced a decrease in criminal and violent activities since the closing of the last carryout at this listed location. Per the letter dated January 4th, 2019, the analysis supports that the last authorized use as a carryout food shop was in 2008, which is a non-conforming use in the residential R8 district. It also states that the use was noted as discontinued and abandoned by the zoning administrator in 2013. This property is in the Broadway East urban renewal area. The prior application by the same representative on behalf of the same appellants for the same use was disapproved by this board on October 30th, 2017. The Broadway East community fears that reopening a grocery store / carry-out will negatively impact the safety of the residents. If the listed location is allowed to reopen as a commercial property, therefore, the opposition for conditional use as a grocery store has been affirmed by the board of the Broadway East Community Association. The opposition has been confirmed. Does planning have a report?
Thank you. Planning Department noted that this property was authorized for use as a carryout food shop, which was a non-conforming use. However, the applicant is requesting approval for what is a neighborhood commercial establishment use, which is a grocery store and not a carryout. Secondly, the department notes that this property is located in the Broadway East Urban Renewal Plan area, where there are certain restrictions on the appearance of the property, exterior alterations and things of that nature. Therefore, the department recommends that approval of this application, if granted, be subject to the condition that all exterior alterations, additions, and signage are completed in accordance with provisions of the Broadway East Urban Renewal Plan. Thank you.
Mr. Woolman, having heard from planning, if we were to be favorably disposed towards your application, are those conditions acceptable to you?
Yes, they are, thank you.
Okay. Tell us about your project.
I'll submit a hard copy of a memorandum which I submitted to your executive director this morning. I'll summarize at this point, and I'll proffer for the board a lot of testimony, if it pleases the board, given the fact that no opposition is present to testify otherwise. This case has a long, long history. Mr. Baumgartner, unfortunately, is very familiar with this long history of this case. It first became before the board back in 2017, where we were surprised to learn there was opposition after all the outrage my client had undertaken with the community. My client lives in the community and actually owns another store in the community, which is widely supported by the community, thus our surprise when we had opposition. We proceeded that day. There were only 4 board members, and there was a split 2-2 vote, unfortunately. The case was appealed to circuit court after a multi-hour hearing. Judge Wanda Hurd issued a 1-sentence opinion affirming the board's decision. So we waited our requisite 1 year, and here we are back again. The case was set in several times this year. Again, we had been reaching out to the community, and the president of the Community Association, frankly, has been very supportive personally of my client and his project. Each time we came before the board, we were very surprised to learn that despite the president's personal feelings, a letter was submitted in opposition. We continually postponed the matter in order to meet with the community on several occasions. We spent 2 Saturdays with the community, myself and my client, discussing with them various conditions that my client would be willing to place on the operation of the grocery store. There are several neighbors who greatly anticipate the availability of fresh food products, et cetera, at this grocery store. We have neighbors here today that would be willing to speak in support if you'd like to hear from them. My client is here. He's very passionate about his business. He lives in the neighborhood. This has been very trying for him to try to get this done over this long period of time. The memorandum I've submitted outlines the long history of the case, includes some quotations from an earlier hearing where several neighbors testified in support of my client and his business. I also have outlined the laws that pertain to conditional uses, which I know the board is very familiar with, regarding their presumptiveness as to being permitted in the absence of any testimony or opposition indicating that this location is not only a bad location for this business, but frankly the worst location for the business in the zone. I don't think you have any such evidence before you. On the contrary, we have support here today. With that, at this time, I would submit, if the board has questions for my client or for me or for any of the neighbors, I'm certainly happy to answer any questions you may have.
Let me ask you this, without referring to the memorandum. What is your understanding of the chief component of the opposition that has been raised to?
My understanding, and I'll even harken back to the very first hearing where some folks came in and had complaints about public safety in general in the city, something we're all unfortunately very familiar with these days. And there was concerns that the previous operator did not take steps to help with public safety. I would submit that this operator already operates a store in very close proximity in the same neighborhood where he does take steps. He does have neighbors here that can testify to that as well, and that he's not the same operator as the previous operator, and that he would run a good business. More importantly, however, I think is the point that public safety is not an issue for the zoning board necessarily in this instance. If we're talking about street crime and people hanging on the corners, et cetera, those are police issues. Those are broader public safety issues that, frankly, my client is not responsible for, and it certainly is in his best interest to try to operate his business as safely as he can. He's indicated he'd like to put cameras outside the store. I think the police would certainly welcome that as opposed to a vacant corner. He's agreed to consider various conditions that we've spent a lot of time with the community discussing over the past year in terms of potentially limiting hours, guaranteeing he'd offer certain food products. I frankly would rather not have those conditions placed on him. I think he's shown to be a very responsible business owner and operator based on his first store, and the fact that the community is not here to discuss any of those conditions with us or testify to them, I'm not seeking that any conditions be placed on him. If the board sees fit, obviously we'd be willing to accept whatever the board would see fit. But the general opposition and what I've heard in various meetings with the community is that sometimes stores attract, certain people loitering, et cetera. And that may or may not be true. Mr. Khan would testify he would take steps to prevent that. But again, those are police issues as well. So to place all those burdens about public safety on my client who simply wants to open another business in the neighborhood, I think is unreasonable.
Let me ask specifically about the willingness to provide security cameras. That is something you're willing to do?
Yes, of course.
Frankly, would you be willing to do that? I mean, even in the absence of, I'm sorry.
I don't have his name.
State your name, sir.
Ansar Khan,
You need to spell it.
ANSAR, last name Khan, KHAN Khan.
Thank you.
This is on a corner, is that correct?
Correct. There's a photograph attached to the memorandum. It's not a very good one, but you can see that it was a corner store for a long time.
Would you be willing to accept the condition that you do put security cameras up at the
Sure.
store? And would those cameras cover both streets, and particularly the alley, which is, I know, historically a concern?
The only other thing the board has required in cases like this, and no matter where it is in the city, carry out or grocery store, is lighting. Is there outdoor lighting outside?
Yes, we do. And also, I offer them community. There is no any fresh vegetable and fruit. They were happy with me that time. And second thing is, we are the only family live in this area and 2 blocks down. We not come from the county. Me and my wife, she's here, Malka. We work 7 days a week. And when they come to front of us, oh, you're nice, you're a blessing, is open up. I was fine, thank you. And mostly something happen in the road accident, something, we are the only people, we have the cameras, 8 cameras. And I asked them again, in case we are busy, I can have some security too. So we are ready.
All right, good.
I don't have anything else.
Yeah, anything else from the board?
Nope.
Okay, I think we've heard what we need to hear.
Thank you very much, Mr. Chairman.
Thank you so
Appreciate it.
much.
Thank you.
Appreciate it. Thank you so much.
So we'll condition that on lighting and cameras, right?
Well, and we should discuss hours.
Okay. I'm gonna jump to the third of the ones that we were gonna do. I'm gonna call, case number 2019-389, 244 South Exeter Street. Bill Nosh. This is a request to use the entire premises as 6 dwelling units, correct?
Yes.
Do we have opposition to this matter? Okay, hold on. Let me just get the answer to the question of whether there's opposition on case number 2019-389. Is opposition signed in? Yeah, hold on.
If you're on the opposition, you can go on the other side too.
We're
please.
in support.
Okay.
So, this case had original opposition that we received by letter, which is in the file. It's my understanding now that there's some agreement has been reached and that the application will be amended somehow. So the board simply needs to hear that amendment and then hear from those who were in opposition as to if they remain in opposition. But the case is currently being called and we can put all that on the record.
Okay. You can swear the witnesses.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Do we have any staff reports?
Yes, we have a letter from LINA, otherwise known as the Little Italy Neighborhood Association. Their letter is dated November 14th. They write that they want to reiterate that they are not supporting any variance at this hearing, regardless of how many dwelling units are being requested. Thank you.
Planning Department reviewed this application, noted that in order to have 6 dwelling units on this property, The board would need to approve a variance of 48% for the lot area requirement, and the department considers that excessive in relation to the amount required in the zoning code. The department is therefore recommending disapproval of the application because the amount of lot area variance needed for approval of 6 dwelling units is excessive in relation to the standards provided in the zoning code. The department would have no objection to use of the property as a multifamily dwelling containing 4 dwelling units. Thank you.
Okay, Mr. Nosh, tell us about your project and what amendment of your application you're presenting today.
Well, when I went to the original planning, they said 300 square feet is what we needed per unit, so that's what we had. But then with all the other stuff, I didn't take into consideration, but I did make a new thing for 4, so it'll be like the 2 together instead of separated on each floor with a kitchen and a bedroom and a bathroom. And
So you are requesting 4
4.
dwelling units.
Mhm.
Okay.
Do the plans have to be resubmitted? How big is each dwelling unit gonna be?
It'll be approximately 600 square feet.
We had 875. Okay.
Lot size is 865 square feet.
Okay.
So, Mr. Chairman, with that amendment, I'm doing math in my head, I apologize. That would be for 300 square feet per dwelling unit for 3 units, that would be 900 square feet. There's a provision in the code that beyond 3 dwelling units, you get credit for half of a lot area, which would be 150 square feet. So essentially, for a property that is 865 square feet in size, the square footage for 4 dwelling units would be 1,050 square feet. So it would be a variance for the 250 odd square feet for that 4th dwelling unit, which is a marked decrease from the 6 dwelling unit variance that would be required.
Mr. Baumgartner, while you have the mic, is there any requirement that this applicant must show in order to?
Sure. So the standard variance requirements still apply. So the applicant should explain to the board the need for 4 dwelling units. There is a very low square footage requirement in a C1 district for residential units on purpose. The idea is to generate streetscape, to generate density in those areas that are C1 districts with residential units, but the same variance standards apply. So it would have to show there's a need for 4 dwelling units, how that benefits the community. In a C1, there's no parking requirement, but just because there's no parking requirement doesn't mean that there's not going to be more traffic congestion with 4 units versus 1. It would be helpful for the applicant to explain how traffic is going to work there. It'd be helpful for the Little Italy Neighborhood Association to provide their testimony in terms of their opposition or no opposition, and any agreement that they may or may not have with the applicant with regard to all of those issues.
Okay, that said, the floor is yours.
Could I let her speak?
Certainly. Whoever's speaking, just state your name so we can record that, and then we'll hear from you.
Hi, I am Giovanna Gia Blatterman, president of the Little Italy Community Organization. And this took us a few weeks to get here and a lot of harassment of Bob and Derek. So now I can have your seat again because I know the whole code. So they've kind of opened our eyes to the new zoning in our community and what can happen to our community. So we kind of seized on the moment with this property, and we're trying to correct the C1 in our property. As you know, most of our complaints are about parking. I know that everybody eventually are going to use bikes, but not at this moment. And as I'm going through the new code, I'm like, my mind is getting crazy because we used to have an off-street parking requirement for vehicles, and now it's an off-street requirement for a bicycle. So We got together informally about 3 weeks ago with the appellants, and we told them absolutely not, the 6 units. I know that the city wants younger people to move into the city and pedestrians into the city, but we have a problem in our community because we are an RPP district, Area 14, which means that you have to get visitor passes and decals for your vehicle.
Let me fast forward you
Yes.
just slightly. Are you agreeable to 4 units?
I'm agreeable to 4. I'm going to tell you how we got here quickly because I don't want to hold you up all day. Yes.
My point that I'm going to make is, we don't necessarily need to know how you got there.
Well, like,
But if what the appellant is presenting in terms of his application, the important thing for us to know is whether or not the community is in agreement with that presentation.
we're in agreement after a lot of negotiation, and I need to have an MOU put into the record because I think it would have been, it's about a 10 or 15% variance with the 4 apartments instead of 3. But in our RPP law for our community, they would still be allowed to get 4 decals, up to maybe 16 decals, and 4 visitor passes. So we made an agreement. We came here with an agreement that they will,
And the appellant.
that they will not seek any type of decals and visitor passes in our Area 14 zoning district, and everybody seemed to be happy with that. We had a meeting. There were about 38 people. I have the sign-in from last night.
Again, with regard to the details.
And everybody
we
was
don't necessarily
unanimous.
need the
Okay,
details.
unanimously, they accepted it with the MOU, which I want recorded in with the,
Have you previously presented that MOU to us, to Mr. Baumgartner?
no, I did not. I did it today, so I apologize. The meeting was held last night.
Okay, you say you did it today, so zoning
I will
has
give it to him. No, I'm going to give it to him assigned. Do you want me to do it right now?
Well, we need it, yes, if we want to be considered, and we want to incorporate that.
Okay, of
As
course.
the terms that the parties agree to. and
Would
the
you like
approval
to
will be
sign? We'll
conditioned on
sign
the
it right in
conditions
front of
set
you.
forth in
Can
the
I
MOU.
read it into the record?
Why don't you hand it up to me?
Oh, here.
Because you understand, we're able to make a record of it by adding it to the
Oh,
record.
yeah, that's
And in
great.
the final decision, it will be referenced and highlighted and attached.
You're the
as,
greatest.
An addendum
Okay.
to the agreement. This is not signed by either party.
We'll sign it right now in front of you.
Okay, because we're not going to do anything with a blank one, I can tell
May I
you
have,
that.
may I have a pen? May I borrow a pen?
Mr. Noge, you've reviewed this memorandum of understanding, this MOU? You're agreeable to all the
Very agreeable.
contents of it? I'm sorry?
1 second, please.
Okay.
But to answer your other question,
Your name?
Rachel Indek,
Rachel?
Rachel Indek, INDEK. To answer your agreement, we did. We agreed to reduce it from 6 to 4. We met with the neighborhood association and got their agreement to it without the parking. And so that was our agreement. And we believe it's still within.
Okay,
Within the
and your
bounds.
understanding of your agreed terms are set forth in that MOU?
Essentially,
You
yes.
reviewed it?
Yep.
And Mr. Baumgartner, are we able to,
Garage right next to it.
hold on, are we able to take that into consideration and make that a part of the,
Yes, we are. If there are any provisions that don't relate to zoning, they're not enforceable by zoning. So if there are provisions that impact some other aspect of the property, but any aspects in there that would be within the ambit of the zoning code, it would essentially becomes any condition that the board would apply anyway.
very well, thank you. So, subject to receipt of a signed MOU,
I'm sorry, sir.
that's okay.
I had to just cross out a couple things, which we both initialed.
Very well, and you're in agreement that all, this MOU contains all the conditions?
Yes.
That the community wishes to put forth, and? you're all in
Yes.
agreement with that. Very well. Anything else that you'd like to offer in support of the application?
will probably be back again in the very near future because they have other properties.
Okay,
But I don't know if I'll be on this side or that side, so.
all right. Well, thank you for your presentation.
Thank you.
Good luck to you. We will now call the case, and make sure Derek gets. Call the case of 2019-373, 1321 Western Avenue. Ms. Hecker? Oops, I wasn't supposed to call that. We're gonna do a little shuffle here because colleague is gonna be the chairperson for this matter.
Nice to see you, thank you.
Yeah, that's, you didn't have to go far.
Counsel, business card?
Yes, I can provide that to you after the,
Oh, I'm sorry. I was waiting for the card. I wasn't paying.
can I give it to you after the hearing?
Your name is fine.
Keith Hinder, Niles, Barton and Wilmer, LLP,
How you spell your last name?
HINDER,
Thank you.
on behalf of Trustworks LLC.
No, you don't have to recall it. It just, I guess he'll swear everyone.
They're all attorneys.
They're all attorneys.
Well, I guess they don't have any. Sorry.
Okay. Good afternoon, Caroline Hecker, Rosenberg Martin, on behalf of the appellant in this case. I'm joined by my colleague, Justin Williams. This is a relatively straightforward negative appeal of the issuance of a building permit for the construction of a digital billboard at 1321 Western Avenue. The board back in 2017, in appeal number 2017-170, approved an application to replace an existing double-faced billboard with a new double-faced digital billboard. I have copies of the board's decision for your review, although I suspect you probably also have them up there. I'll just pass these up for you to review. The written decision, like every other decision the board issues, at the very end in red ink in bold capital letters indicates that that authorization is valid for 1 year from the date of the written decision, and that the applicant has 1 year from the date of the written decision to obtain a building permit. The 1 year period from the date of the written decision expired on November 21st, 2018, at which time no building permits had been issued for the proposed billboard. On January 8th, 2019, however, the city issued a permit to replace the existing double-faced billboard with a new digital billboard per BMZA decision 2018-170 as per plans, as per code. That application, that BMZA decision actually relates to another property. It appears that was an error. I can hand out to you a copy of the, I'm sorry, I didn't give you a copy of the board's decision. There should have been an extra copy up there for you. I suspect you have it already, but I'll give you one of these also. There should have been 6 of each of them. You're welcome. In any event, you'll see in the city's permit records that the permit that was ultimately issued in January of 2018 referenced a 2018 BMZA decision, which actually related to a different property. It appears that was an error. It's not clear where that error came from, but the correct BMZA decision relating to this permit is the 2017-170 case, which again expired in November of 2018. The permit that was issued in 2019 was amended in September of 2019. It was permit number 2019-76217, and this negative appeal of that permit followed. It is, I think, undisputed that more than 1 year had lapsed from the date that the board issued its original written decision approving the conversion of the billboard to a digital sign. Therefore, it was clearly inappropriate for the city to have issued a building permit for the digital billboard, and the city has the authority at any time to revoke a permit that was improperly issued. And furthermore, the issuance of a permit does not itself create a vested right, nor does it validate an unauthorized use. That's clear in the case law, and the city, therefore, even in the absence of a negative appeal, should revoke the existing permit for the conversion of the digital billboard. I think what we're going to hear from the applicant for the permit is a couple of things. I think we're going to hear that we're appealing the amendment of a permit, not the original permit. But I would submit that if the amendment was predicated upon a permit that was improperly issued in the first place, that both the amendment and the original permit should be revoked by the city. Moreover, even taking for the sake of argument that the amendment of the permit couldn't be appealed at that late juncture because the original permit had not been appealed, I would argue that the city anyway has the authority to revoke a permit that was improperly issued, where the zoning authority had plainly lapsed. In addition, the fact that, I've looked through some case law to see if we could find any case where the appellate courts in Maryland have looked at this and determined that an amendment to a permit is something that can be appealed if you didn't appeal the underlying permit. And while the issue hasn't been squarely decided, it was addressed in Armstrong versus Board of Municipal and Zoning Appeals. It's 169 Maryland App 736. And in that case, the appeal that was at issue was an appeal of the amendment of the permit, not the appeal of the underlying permit. And the Court of Special Appeals in that case they didn't discuss the issuance or the appeal of the negative, the negative appeal of the amended permit, but they didn't find any fault in the fact that the appellant had not challenged the issuance of the underlying first permit when they appealed the amended permit later on. And I think, what the other thing we're going...
Can I interrupt?
Yeah.
What was the permit amended for?
It was amended to add, I have a copy of it actually, it was amended to add something relating to the parking provided for the property.
In this case, we're only talking about the name of the contractor, correct? Not something as substantial as parking.
We are only talking about the name of the contractor, but I would still argue that if the original permit was not properly issued in the first place, any amendment to it should also be invalid, regardless of how small the amendment was.
It's up to the city to deal with the permit, not for zoning.
But this is the board that reviews all decisions of the city in terms of issues relating to permits, and even though the thing...
You just said that the city could revoke the permit.
Through this body. This is the job of the zoning board, set forth in the city charter. This is the board, not only the zoning board, it's the Board of Municipal and Zoning Appeals. And under the city charter, it's this board that has the authority to look at actions of the zoning administrator, of the permits office. In fact, I think I have a copy of the charter provision. It's Article 7, Section 86 of the city charter gives the BMZA it says the board shall have such additional powers to examine, review, and revise acts or rulings of other departments and officers of the city affecting the construction, alteration, use, or operation of land or buildings in the city, and other charges as may from time to time be conferred upon it by law, but the powers conferred in the charter shall not be diminished or abridged by ordinance, nor shall the board have any power to review or alter determinations of the Planning Commission.
Why wasn't an opposition to the original appeal filed? Or why
well, that's a fair question. We monitor the issuance of building permits in the city and for
who are you saying?
We, on behalf of our client, I represent Clear Channel Outdoor, which has an adjacent billboard at 1325 Western Avenue, and on their behalf we monitor the issuance of permits for properties that we're interested in, that they want to keep tabs on what's happening. We knew that the board had approved the original conversion of this billboard to a digital sign in 2017, and so for a year following the date of the written decision, we would periodically review the city permits to see what had been issued. And at the end of that year period, when no permit had been issued during the city's legal authority to issue a permit based on the zoning approval, no permit had been issued, we figured that they had abandoned their desire to convert this to a digital billboard and stopped tracking it as closely. When the permit was issued in January, there was no reason for us to think that the city would have been issuing a permit at that point, because at that point the city's authority to issue the permit had lapsed. So when we finally noticed that construction was starting on the permit, on the property in September of this year, late August, early September, we went and we looked in the city zoning records and we saw...
Sorry, I'm confused, and I'm not being glib. Are you saying that the reason why you didn't originally oppose it is because you didn't realize it was happening?
We didn't oppose the BMZA application. We didn't oppose we didn't file a negative appeal of the permit when it was issued in January of 2019.
Wouldn't that, if you were against the existence of the billboard, wouldn't that have been the natural time to stand up and say, we don't want this to happen?
You mean when, in January or in?
Before the permit was issued erroneously.
I want to be clear, we're not saying that they can't have a digital billboard here. We're saying that if they're going to have a digital billboard here, they need to go through the right process to get that approval. They went through a process to get the approval, and then they let that approval lapse. And they shouldn't be allowed to go back retroactively and say the rules don't apply to us. You should give us an exception. We should be able to build this thing based on an approval that we let lapse. If they want to go ahead and reapply for a BMZA, reapply to the BMZA to convert the billboard to digital at this point, that is certainly within their, their ability to do so. We're not here to say that they can't ever have a digital billboard. We're saying that there's a process in place for them to get that approval, and that they should have to follow it. And, for me, this hits a little bit close to home. I don't know that any of the current board members were on the board a few years ago. I know Mr. Baumgartner will probably remember this, but I represented a homeowner who had bought a piece of property up on Roland Avenue that had been subdivided from a larger parcel. And he hired an architect and got a permit and built a house. And he was living in the house when one of his neighbors turned around and said, hey, I think that house is too close to the road. And they called the city. The city went out, looked at it, and they said, yeah, this guy should have gotten a variance. We issued a permit improperly for this guy to build his house. It's 10 feet too close to the road. And they revoked his permit after he was living in the house. He had built the house with a permit that he had gotten from the city and moved in. And then the city revoked his permit and made him go back. And that's when I got involved, and we had to reapply for a variance, which the board ultimately granted. I mean, there's a process for getting the approval. And we're saying in this case that the applicant in this case, who happens to be a business as opposed to an individual, should be treated exactly the same as the city has treated individuals in similar circumstances. That where a permit was issued erroneously and improperly, they should revoke the permit and make the applicant go through the regular process that everybody else has to go through in order to get the approval, and that it would be arbitrary and capricious for the city to treat this applicant differently and better than they treat other applicants that are similarly situated.
Ms. Hecker, doesn't that discretion of revocation lie with the city of Baltimore and not a private entity?
I'm sorry?
Doesn't the discretion to revoke a permit lie with the city solely and not with a private entity?
Absolutely. The city is the only party that can revoke a permit.
So I'll give you a very brief hypothetical. Say there's a very large-scale development project. I don't know, 2 acres worth of land. I mean, many millions of dollars. It takes 5 years to build, 10 years to build, which is not out of the ordinary. And say the underlying permit is amended through the different contractors, there's issues in the building process. So we're 5 years down the road, the project is half built. Under your argument, you could then challenge an amendment to a permit when half the project's already built and the only substantive thing that you're alleging is in violation is what was issued 5 years ago.
Yes.
And certainly the city would have the authority to revoke that permit. But again, I would say, what is the authority of a private entity to require the city to do that?
We cannot require the city to do anything. We are requesting that the city exercise the appropriate discretion to revoke a permit that was not properly issued in the first place. The state of Maryland has squarely rejected the doctrine of zoning estoppel, under which, applicants who argue that they should be allowed to proceed with their project because they've invested a lot of money in whatever their project is based on some preliminary level of approval, but they haven't gotten to the point where they've vested their rights, that the city or the entity could, or that the jurisdiction couldn't go back and then revoke that permit, that the jurisdiction is stopped from doing so. The Court of Appeals addressed this as recently as 2010, and they have squarely held that Maryland does not recognize zoning estoppel. And I think that this case is really no different from the other case of a homeowner who had built a house and this.
It's different, because zoning didn't revoke the permit in that case.
I think they did, actually. That's how we ended up getting a variance. It was a zoning issue. There was squarely on a zoning issue that the thing was revoked.
So in that prior case, which I guess by analogy, we're talking about here by example, in that particular case, the Department of Housing and Community Development, in which the zoning office is located, had revoked that permit. Mm-hmm. But again, that's on the city of Baltimore's discretion there. There wasn't any private entity requiring that to occur, right? There wasn't a private entity going to court to get an injunction, et cetera, et cetera.
Respectfully, there was a private entity. It was a neighbor who lived 2 doors down who was calling the city every day saying, you have to revoke this permit. This isn't fair. They built their house too close to the road. And the city didn't in that case say you have to file a negative appeal to get this in front of anybody. They just went ahead and revoked it.
But that was the city's discretion to do that because the city had determined that based upon public policy and applying code, that it on its own as a city would revoke that permit. I'd follow up my question earlier with this, and it's kind of, I guess it's something that we should have gone into earlier, but the purpose of a negative appeal is to stop things in its tracks, right? So if the city issues a permit illegally or incorrectly for whatever reason, the idea of that 10-day time limit is to say, whoa, hold up, stop, don't spend money, don't build something, let's take a look at this and find out whether or not an error had occurred. So if that was filed in January of 2019, that would have occurred. In this case, 9 months later, we're kind of past that phase.
Except that how in January would...
But I would ask, as a preliminary matter, how do you have standing to file this appeal here today? So if what you're really attacking is the January permit, how can you, what is the standing issue, number one, to allow that amended permit, which you got into a little bit earlier, to challenge that amended permit? So in other words, if the board finds that you're 9 months too late, essentially, that's certainly something that the board could find, that you should have filed 10 days from January something in 2019. How does that impact your ability now to come before this board, if that makes sense?
If the board found that the appeal should have been filed in January.
Correct.
I would submit that even in the complete absence of a negative appeal, this board has the authority to revoke the permit. I don't think you need a negative appeal in front of you to revoke a permit. I think what you have is the reason that this is in front of the zoning board as opposed to just being done in front of or by the zoning administrator or in the housing department is because the opponent, in this case Clear Channel, is represented by counsel who knows to file a negative appeal of a improperly issued permit.
Doesn't housing have an administrative appeal officer that would hear appeals?
They do, and we have actually filed a parallel appeal on the housing code issue, although I frankly think in either case it belongs properly in front of the zoning board. In the zoning board's capacity as the Board of Municipal and Zoning Appeals, it's all appeals of administrative decisions relating to buildings and land in Baltimore City fall under the zoning board's purview. And I realize it puts the board in a tough position to have to say, look, this permit was improperly issued, we think it should be revoked. And again, we're not saying that it should be revoked permanently and that there should be no chance for this applicant to ever have a digital billboard at this location. We're saying there's a process that they should go through, just like anyone else who wants to put a digital billboard up would have to go through.
And then lastly, your client's billboard and this particular billboard, are they on the same lot or separate lots?
They're on adjacent properties, which maybe gets to your question about standing.
Correct.
Clear Channel leases a property adjacent to this property at 1325 Western Avenue. As I'm sure the board knows, standing at the administrative level is incredibly broad, but we are in a prima facie aggrieved party as the operator of the property immediately adjacent to this one.
So they're two separate lots. They're not the same lot.
They are two separate lots. That's correct. So for these reasons, we believe that the permit should be revoked. Even in the absence of a negative appeal, we think that the permit was improperly issued on its face, well in excess of the 1 year period that the applicant certainly had notice of, being that it is advised in bright red ink in capital bold letters on the decision that they have 1 year to get a permit.
Good afternoon. May it please the court, Keith Hinder on behalf of the FLE Trustworks LLC. Now we have a memorandum in support of our argument. If I could circulate that, please. And at the outset, we have two procedural requests.
I'll just pass it on.
And the first procedural request that we have concerns the dismissal of the negative appellant's appeal here because it's procedurally deficient. And the second procedural request concerns an extension of time to grant Trustworks an extension sufficient to match the time when Trustworks ultimately acquired the permit on January 8th of 2019, to eliminate any uncertainty. My colleague provided a nice narrative of the procedural history, but if I could review this history once more to emphasize some important points here. The genesis of this controversy concerns an upgrade to an existing billboard located at 1321 Western Avenue. And my client requested the upgrade and received zoning approval by this very board almost 2 years ago. In fact, in 2 days, we're going to celebrate the 2-year anniversary from when this very board granted my client the zoning approval to go forward with the upgrades to its billboard. And it's memorialized in a resolution on November 21st, 2017. Now, after receiving the zoning approval, my client was diligent in applying for the necessary building permit in 2018. And in fact, my client's application was reviewed and accepted by the Department of Housing and Community Development on August 27th of 2018. And the record as set forth in our memorandum, specifically subsection E, establishes that Trustworks LLC was proactive in trying to acquire the building permit within 1 year. We don't dispute the fact that, as Ms. Hecker said in red print, yes, you should have the building permit within 1 year. We did a number of good faith, proactive steps to acquire that building permit within 1 year. Now, despite our proactive and good faith efforts, the permit was not finally issued by the Department of Housing and Community Development until January 8th of 2019. And this is memorialized by Mr. Braverman's signature in his capacity as the building official for the city of Baltimore. Now, we're here today because Clear Channel decided not to appeal the underlying resolution from November 21st of 2017, where they had a right for judicial review, or to file a negative appeal to the underlying permit, which was issued on January 8th of 2019. We're here because of 2 amendments. The first amendment was September 3rd of this year, where the sole purpose of this amended permit, where we had to pay $25, was to name a contractor, a prime contractor. Then there was another negative appeal that was filed by Clear Channel, and that was on, so the second amendment to the underlying permit was on October 1st of 2019, and that was for the sole purpose of naming an electrical contractor. So procedurally, we're here today because Clear Channel waited well over a year, in fact, 20 months to file appeals to an amended permit. And it's clear based upon the zoning code and the BMZA rules that only zoning decisions are subject to a negative appeal by the BMZA. In particular, I direct the board's attention to 17-201 of the 1971 zoning code, which governs here. And pursuant to that provision, a decision of the zoning administrator, including the issuance of a violation notice under subtitle 1 of this title, may be appealed to the board by A, any person aggrieved by the decision, or any officer, department, board, or bureau of the city affected by the decision. In addition to this provision, the BMZA rules further support and buttress the fact that you can only appeal something that's issued by the zoning administrator. And it specifically provides that under section D1, subsection I, negative appeals may be noted by any person aggrieved by filing a letter at the office of the board within 10 working days of the issuance of the permit by the zoning administrator. Not by the Department of Housing, the zoning administrator. Here, Clear Channel's negative appeal is fundamentally flawed as it derives not from the issuance of a permit by the zoning administrator, but instead it relates exclusively to the housing department's issuance of the first and second amendments to the underlying permit. And these amendments happened in September and October this year. In addition to that procedural deficiency, the negative appeal has not been timely filed. Again, the BMZA rules are clear that negative appeals may be noted within 10 working days of the issuance of the permit by the zoning administrator. Here, Clear Channel chose not to file an appeal to the underlying resolution and didn't file an appeal to the original permit that dates back 10 and a half months ago to today in January of this year concerning the original permit that was issued on January 8th.
When did you file for the permit?
The filing was sometime in the summer
Of 2018?
of 2018.
Okay.
It could be in the spring. I'm not positive as far as the actual date.
Until January for them to issue it?
Yes.
Is that unusual?
So you raise a good point there. The application was reviewed and accepted by the Department of Housing and Community Development well within the one-year time frame, which was October 27th of 2018. Okay, thereafter.
So the application for the permit was approved October 27th, 2018?
Correct.
The application submitted?
So you need to have the permit in hand is the argument from Clear Channel. We have it approved and accepted by the Housing Department, but you need signature ready set plans that are prepared by the Housing Department. And here the record illustrates that there were numerous good faith efforts done by my client Trustworks to obtain the permit within 1 year. And specifically, as part of the permit procedure, as I alluded to, housing requires original signature ready set plans to be physically delivered to the plans examination office.
Before the permit is issued?
Correct. Before we have it in hand.
So you had the approval on the 27th, and then when were those plans submitted?
So we went back and forth and with the Housing Department. The Housing Department tried to forward the plans on November 5th of 2018, okay? There's an email exchange, a volley back and forth that is indicated in our memorandum where the link that was forwarding us the signature ready set plans, which we then had to submit to our engineer located in Chattanooga, Tennessee, to provide a wet signature and a seal for, those signature ready set plans were not forwarded for an additional 10 days. So that brings us to November 15th of 2018. And this is all within a year of the issuance of the board's decision, the board's resolution from November 21st of 2017. And that gets to our second point of arguing here and requesting, because it's been demonstrated by the record, for an extension of time to permit us the sufficient time which matches when we ultimately acquired that permit in January of 2019. There were some delays by the Housing Department concerning the forwarding of the signature ready set plans. That bumped us back a bit. Again, the record demonstrates our good faith efforts here, and we'd ask for an extension of time that would permit us the time necessary to ultimately acquire the permit on January 8th of 2019. And again, that eliminates all the uncertainty here.
So wait, you asked who for an extension of time?
We're asking the board.
Oh, us.
Yes.
Got it.
Yes. And the board's grant of the extension eliminates all the uncertainty, because what Clear Channel is going to do, if there's going to be a dismissal of this appeal, which there should be, based upon the procedural deficiencies of the negative appeal, they're going to go right back to housing and argue that there's an issue with the issuance of the Housing Department's amended permits
Got it.
because
So
of this
you're
extension.
asking for a retroactive extension from the date till, from October, basically, end of October till when it was issued in January.
Yes, ma'am. It's approximately 45 days.
Okay.
It'll be from November 22nd until
Exactly,
January.
exactly. And the record, as stated in subsection E of our memo, shows that we were very proactive to get this permit within 1 year. So that's why we're asking for the extension, because even if this negative appeal is dismissed, which it should be, we feel like we'd have an additional controversy with the Department of Housing and Community Development if it's not ruled concerning this extension. I mean, what they're trying to do, it's like the fruit of the poisonous tree attack in constitutional law under the Fourth Amendment.
That doesn't apply in zoning?
It does not. It does not apply in zoning, and but that's what they're attempting here. And it is so.
It's a clever argument.
It's not applicable to what we're dealing with here concerning the zoning appeal that's before the board, as well as the issuance of the building permit.
Question for you. When it got close to November the 21st of 2018, and you didn't have the permit in your hand, why didn't you apply for an extension then?
That's a fair point. However, the record demonstrates that we were in good faith and proactive trying to get that permit within the 1 year.
Right, but when you knew it was getting, I was just curious, why?
Right.
Did you know it was getting close and it just slipped your mind, or like?
As with a number of projects, I think, there's a lot of things that my client is dedicated to concerning its development activities. And quite frankly, we could have applied for that extension, and perhaps that would have been prudent to do so. However, here, we think that the record is very clear concerning the proactive attempts to acquire this permit within 1 year. We get the zoning approval. I mean, we are 2 years away from the underlying zone.
Regular practice for housing to issue a permit after the year is up? I mean, is that something?
Yes, there is actually, if I could point out an example of that.
Yeah.
And this is recently, and it was issued where we have a building permit.
Is it at their discretion to issue that after the fact? I mean, they're obviously know that it's been a year and they issue them anyway? Is that happen regularly?
I can't speak for the housing department, but I can tell you that recently, and this dovetails with the timeline that we have here concerning the issuance of a permit well after a year of the underlying resolution by the board. And this concerns case BMZA 2017-431, and it concerns a University of Maryland Medical System request to construct additional floors at a hospital complex located at 800 Linden Avenue. Now, the zoning resolution in that case was issued on October 4th of 2017. Yet the building permit was not issued until August 15th of 2019. That's a year and 10 months after the underlying resolution. Not only that,
And presumably, if no one files a negative appeal, nothing's going to happen and everything's going to proceed.
right, and a negative appeal is completely inapplicable to this context.
I understand.
So, but not only that, you have the housing department issue the building permit over a year after the underlying resolution. The application wasn't even made until a year and 5 months later. Here we have proactive attempts by my client to acquire the building permit within the year. So the record's clear concerning the procedural deficiency of a negative appeal at this juncture concerning an amendment to an underlying building permit. But we'd also ask, and this would dispositively control the case, for a retroactive extension of time to permit us the time necessary to ultimately acquire that building permit on January 8th of 2019. Thank you.
I'll be brief in rebuttal. I think we are not hearing anything from Trustworks that says that they actually got the permit within 1 year of the board's written decision. They concede that the permit was not issued within 1 year of the board's decision, as is specifically directed on the board's decision in bright red ink. And they're basically saying, we tried really hard. You should give us credit for trying really hard and retroactively extend our approval to give us enough time to have gotten the permit in a timely manner. And that's just not the way things work. There are rules. Everyone else follows the rules. The fact that in one other case there may have been a permit that was issued after the expiration of the board's decision that no one challenged, and it's entirely possible that no one was paying that much attention to it. All I can say to that is two wrongs don't make a right, that the city certainly has the authority and should revoke permits that are not properly issued in the first place. Again, as I said before, we're not suggesting that there is no path to approval for them. There is a path under the zoning code for them to get the approval that they need. What we're saying is that they need to go through that process. If it means starting over, it means starting over. But they should have applied for an extension in a timely manner. Other applicants, our clients routinely ask for extensions where it's not possible to get a permit within a year. I will concede that a year is a short period of time to go from getting your zoning approval to getting your construction drawings done and submitted and approved. And this board considers extension requests at its meetings regularly, so the board knows that it is difficult to get permits issued within a year. But there is, again, a process for applying for an extension of that period.
Ms. Hacker, can you address how your client has been aggrieved?
So the issue with, it's a fair question. The issue with digital billboards is that they change every 8 to 10 seconds. And Clear Channel has always represented to the city that we would not put more than one digital billboard along a view corridor where you could see more than one billboard at the same time, because we want to minimize the risk of any type of traffic accident or distraction by things that might be changing in a non-synchronous fashion. And where you have another billboard that is on the adjacent property from this one, we think it's not in the city's best interest, it's not in our interests to have another billboard that could distract people coming up and down the highway if it's not synchronized with the timing of our board as well.
Is that a requirement?
Are you
I'm
here
sorry.
for as a public safety interest? I mean,
Well,
how's
it
Clear
makes,
Channel's I don't find that to be aggrieved at all. Do you have any other?
Well, on the issue of aggrievement, I mean, we are prima facie aggrieved as the adjacent property operator, regardless of a competitive interest or any other type of interest. Our billboard is located at 1325 Western Avenue, which is right next to this one.
Ms. Ecker, a quick follow-up to something you had mentioned during your case in chief. You had mentioned that the board's authority to hear this wasn't necessarily under the zoning appeal context, but under the municipal appeal context. Is there a particular provision in the old code or the current code that you could point towards that would give the board the authority to hear this?
I would direct you to the city charter, Article 7, Section 86.
Is it just
I can give you a copy of it, in fact.
just so I have this clear? In the prior zoning code from 1971, Section 17201, under who may appeal, Mr. Hinder had mentioned this as well. It says a decision of the zoning administrator, comma, et cetera, et cetera. So you're not bringing this action under that provision. You're bringing it under a separate provision.
I mean, I would submit it's under both. This is a decision of the zoning administrator, contrary to what Mr. Hinder is saying. The zoning administrator is the one who makes the zoning decision to issue the underlying permit. And if the underlying permit is invalid, then any subsequent amendment to it is also invalid.
So you would be correct in that the underlying permit, which was issued in January of 2019, would have been reviewed by the zoning office, hopefully in compliance with the board's decision. But the amendment in September would never have gone through the zoning office. Is that your understanding?
I'm not 100% sure who reviews amendments to permits.
Okay.
Candidly. But again, as I said before, we're not suggesting that there isn't a path to approval for them. We just think that they should have to go through it.
Saying that, 'cause it's disingenuous, given that the code has changed and what it would mean for them to get approval. It's not the same as when they went the first time. I mean, I don't.
If it's more difficult for them, it's more difficult for them.
I
mean,
understand, but this is not, I don't feel like that statement helps your cause.
And Mr. Hinder, was there something that you were going to add on to
Yes.
in terms of Ms.
Thank you,
Hecker's
Mr.
response?
Baumgartner. To sustain Clear Channel's challenge here would be to upend the entire permitting system for the city of Baltimore. We're talking about grave consequences that were alluded to by Madam Board Member here concerning the consequences if this is in fact revoked, this permit.
I disagree with that too. I mean, these are consequences to you in this specific excuse me, not consequences overall.
Right.
I mean, this is about, yes, should you have asked for an extension back in November of 2018? That's the question.
Well, in reliance,
What discretion the board has now to give you an extension, a retroactive extension.
I understand that point, and I think it's compelling. However, in reliance on the duly issued permit that dates back to January of 2019, my client spent over $100,000 concerning the construction of the digital billboard. It was duly issued. There were no objections at the resolution stage. There were no objections at the
strong arguments
building permit stage. And if I could steer it back to the standing here, we are talking about our competitor. Clear Channel has 90% of the billboards here in Baltimore City. And they're concerned about this billboard based upon the close proximity.
Public safety, didn't you hear them?
If I could point to a Court of Appeals decision that would say that public safety, especially not in this circumstance, is not applicable. Maryland's highest court, they held that a person whose sole reason for objecting to a zoning board's action is to prevent competition with his established business is not a person aggrieved. And that's in
Where's that from?
Creechman versus Ramsburg, and that's 224 Maryland
209/1961.
Leave a copy of that case with us. Do you have it?
Yes. I don't have the case. I will give you a direct quote from the case, however, that the zoning laws give him, the appellant in this circumstance, no standing to do so when the sole basis for invoking them is the prevention of competition. I'd be happy to furnish that
No, I mean, and
case
I hear you, and I
specifically.
would 100% agree, but they are arguing that because they are the adjacent property, it doesn't matter why they're here. I mean, as
Right.
far as complaint, they could be here regardless.
And this case says that that is not a valid basis for the competition. They actually, in their negative appeal, there was no statement, not one solitary reason given as to the establishment of their standing.
May I address that point? That's because at the administrative level, standing is incredibly broad. You may be correct that when we get to the circuit court level, we would have to document an aggrievement. That is 100% true, and competition at the circuit court level is not a sufficient ground for standing. But at the administrative level, there's no such limitation. At the administrative level, standing is incredibly broad. And this board, as this board regularly hears from individuals who have a variety of interests in the matters that are before the board that may not be what one would traditionally consider to be interests that constitute standing. But at the administrative level, the board can absolutely hear from folks who have competitive interests, who are located far away, who may not be within sight and sound of the subject property.
And we have heard.
Right. But that's not an issue at this level, it's an issue at the circuit court level.
I don't have anything else. Does anyone else?
Nope.
All right.
Thank you.
Thank you.
Thank you.
Thank you all.
Appreciate it.
Okay. I think I just grabbed all your stuff. There you go.
Okay.
Yeah.
Attorney,
We're voting now because Avery has to.
Okay.
We're voting on the three.
On these three?
Mm-hmm.
All right, so we'll go off the record.
Suspending the vote.
Yeah, the chairman would like to take a 5-minute, just make an announcement.
Yeah.
for 5 minutes.
We're going to take a 5-minute recess. We have some business to take care of here, and then we'll resume the docket after that time. Thank you.
Stokes came in.
Let's see. Yeah, Derek, come around front. All right, it's fine.
I'm your former
I was like, Avery in there like, I was like, I don't have anything to ask because she hit him.
Yeah.
I'm right behind you.
Yeah, 'cause I was like, I'm not in this. It's like, what is your beef? Okay, we're going to go back on the formal record. Now I'll call the case of, which one is it? Oh, 2019-394, 2125 Maryland Avenue, No Land Beyond LLC. Good afternoon, folks. This is a request to use portion of premises as a tavern with live entertainment and retail space. Is that correct?
That's correct.
Okay. Please swear the party.
Yes, raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth?
Yes.
Okay, do we have any staff reports?
Yes, Planning Department reviewed this application, noted that this property is in the Charles North Urban Renewal Area. The urban renewal plan does not prohibit the proposed use. However, the plan designates this property as part of a contributing structure in its Appendix D and provides guidelines and standards for renovations of such existing contributing structures. Therefore, The department is recommending approval if granted be subject to these conditions, in addition to any other conditions the board may establish. All exterior additions and alterations are completed in accordance with plans approved by the Department of Planning. A copy of the use and occupancy permit for the premises must be kept on the premises and available for inspection by representatives of Baltimore City at all times. A copy of the written approval of the board of the live entertainment provided on the premises, including details of any restrictions or limitations on the live entertainment provided, must be kept on the premises and available for inspection by representatives of Baltimore City at all times. And a copy of all other permits and licenses required pursuant to the written approval of the board must be kept on the premises and available for inspection by representatives of Baltimore City at all times. Thank you.
Thank you, Mr. French. Council, having heard those conditions, are those conditions, should we be favorably disposed towards your application? Are those conditions acceptable to you?
Absolutely.
Okay. Tell us about your project.
Abraham Hurdle, on behalf of No Land Beyond LLC. With me is the applicant licensee who is applying for a liquor license. This location is one of a handful that are covered by a special legislative change to the Alcoholic Beverages Act. I believe it is Article 12-1603, which is one of the first times the city's creating new BD7 seven-day tavern licenses. These locations, I think there's 8 of them in total. This is probably the 3rd or 4th one to come up. They're kind of specially curated to go into these certain locations, special operators who have been kind of vetted very thoroughly by the community and by the legislators and the people involved in this legislation. Kelly Cross, who was here earlier and who had to leave for a meeting with the councilman, unfortunately had to leave. He represents, I believe, it's the Old Goucher Neighborhood Association, and they're in absolute support of this. He didn't provide a letter because he was going to testify today, but he had an integral part of the legislation. And this is one of those weird situations where the legislation allows us to apply for the liquor license actually prior to the zoning, which is unusual in every other liquor license situation. And they have been granted that liquor license at a hearing, I want to say about 3 weeks ago, 3 or 4 weeks ago. This is going to be a board game bar, is the best way I would describe it. People are going to play board games and other sort of kind of hands-on games. And there's going to be alcohol, which is just a part of the kind of the young people in the crowd that's kind of catered towards that at this point. Ultimately, there are going to be occasions where these games are going to be guided and there's going to be new events and things of that nature. So we did want to have live entertainment. There will be music on occasion, but I think that when I talk to licensees or prospective licensees, we talked about like once or twice a month. It's not something that's going to be there all the time in terms of musical acts. It isn't going to be loud.
Several days a week you'll
No, and the music's going to be kept almost exclusively to the basement space. It says first floor here, but it's kind of like a split level, almost like a home. So it's kind of like half down. And that's bricked in, and there's double insulation. So any noise down there, not that it's going to be that loud, really shouldn't travel in any capacity. That room is filled with tables, which have chairs. Again, people are playing board games. There's a retail space that's part of this process where they're going to sell board games and other things accessory to that as well. The bar's on the 2nd floor. The space is actually, to be honest, very striking. Beautiful hardwood, beautiful arches. It's going to be a really pretty space. I think some of the renderings that I've seen make it look really outstanding. But this shouldn't be...
Alcohol consumption be allowed in the basement as well?
Absolutely. Absolutely. And overall, this isn't going to be a rowdy place by any nature. One of the things that is beneficial to this, and I do think is great, is that the front entrance is going to be renovated in some capacity. Right now, it's kind of like a aluminum structure with glass, and it's going to be redone to just look more in keeping with the theme of this bar and the neighborhood as well. So it's going to be cleaned up a little bit from kind of what I would imagine is like a 1980s commercial front entrance. The operators are experienced in this industry, and ultimately they should be very successful there. They did meet with the neighborhood, and there is an MOU that has been signed. I think we might have a copy of it signed. We do have a letter of support from the Charles North Association, the other community group. That is our only copy. I do apologize. And the MOU is a part of the liquor license as a restriction. And it contains essentially, I don't say 0 restrictions, but it requires them to operate within the bounds of the law and keep in communication with the neighborhood.
Okay. Would you like to supplement the record by providing a copy?
We can absolutely provide a copy of the MOU at probably tomorrow, even today maybe. I believe it was signed with the neighborhood this morning.
Yeah.
2 days ago.
Yesterday.
Yesterday.
Okay.
Yesterday.
Any questions from the board?
Now I learned something today, a board game or. Who would have thought?
Interesting. Never played Monopoly in the park before.
Now there's a place.
First time for everything, huh? You got some time, huh? Okay.
No questions.
All right. Thank you. Thank you for your presentation. Good luck.
Thank you. Are we?
You're through with this
I'm in
one?
the next case, I believe,
Okay,
as well,
great. So
potentially.
I thought. So we'll formally call the next case, which is 2019, that's 395, 17 West 24th Street, Wolf Culture LLC. There's a request to use portion of premises as a tavern with live entertainment and outdoor seating.
Abraham Hurdle, on behalf of Wolf Culture LLC. With me is the applicant, Brian Rainier, on behalf of Wolf Culture LLC.
Okay, well, let's get Mr. Rainier.
Raise your right hand, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
How do you spell your last name?
Raneere.
Okay, do we have any staff reports?
Yes. Planning Department reviewed this application, noted that this property is contained in the Charles 25th Urban Renewal Area. This urban renewal plan does not prohibit this proposed use. In fact, it recognizes it as a conditional use in the plan. The plan, however, does designate this property as a notable structure in its Appendix B and provides guidelines and standards for renovations of such existing structures. Therefore, the exterior alterations or remodeling of the premises must comply with the plan's Appendix A, known as design standards. The department recommends that approval of the tavern, if granted, be subject to these conditions, in addition to other conditions the board may establish. All exterior additions or alterations are completed in accordance with plans approved by the Department of Planning. A copy of the use and occupancy permit for the premises must be kept on the premises and available for inspection by representatives of Baltimore City at all times. A copy of the written approval by the board of the live entertainment provided on the premises, including details of any restrictions or limitations on the live entertainment provided, must be kept on the premises and available for inspection by representatives of Baltimore City at all times. And a copy of all other permits and licenses required pursuant to the written approval of the board must be kept on the premises and available for inspection by representatives of Baltimore City at all times. There is a request contained in this application for outdoor seating. The department recommends disapproval of the proposed outdoor seating, as only outdoor dining adjoining a restaurant or carry-out food shop is authorized by the zoning code, and the applicant is not requesting approval of a restaurant or carry-out food shop. Thank you.
Thank you, Mr. French. With regard to the conditions identified by planning, should we be favorably disposed towards your application? Are those conditions acceptable to your client?
Yes.
Okay. Tell us about your project here.
This is another one of these tavern licenses, the BD7s, that fall under, again, 12-1603, which is a recent legislative change to kind of revitalize that kind of North Charles corridor that's just south of Charles Village. Mr. Kelly Cross, who, as I mentioned before, was previously here, he was an integral part of changing legislation and getting these licenses prepped for issuance. Currently, Fadden Sodden, as well as, I believe, Dutch Courage, which is going in just on the corner on 23rd Street. One of them set to open, one of them has been open and has been, these bars are already attracting a lot of very positive attention. And again, these are, the owners are kind of hand-picked to operate them. Mr. Rainier has, was 30 years approximately, correct? Almost 30 years in the industry. Including, I want to say, more than 2 decades in San Francisco's competitive market, and here for 5 years, is that correct?
I've been a Baltimore resident for 2 years, more than 2 years now, and I moved here from San Francisco to work on the Fadden Sodden project, which is currently operating on 23rd Street. So I sort of came to bring my expertise in opening a multifaceted bar, restaurant, gathering space, because I've been involved in one in San Francisco that's just celebrated its 20th anniversary there, which kind of makes it an institution in San Francisco. So I was excited about coming to Baltimore, where my brother's been a resident for 30 years, and so I'm quite familiar with the city. I grew up in Philadelphia originally before I moved to San Francisco in the early 90s, and but I've been coming to Baltimore for, all of those years, probably at least once or twice a year, so I'm pretty familiar with the city and fallen.
You live in the city too, correct?
I live in the neighborhood, in fact.
And
I live in Old Goucher.
And you're an owner of this actual building as well, so you're both
Yes.
invested in the neighborhood in terms of your home and in
Yeah.
terms of this building that you've purchased for
Exactly.
this business.
I purchased the building earlier this year for the purpose of developing this project.
Wonderful. Okay.
And we've asked for live entertainment and outdoor seating. The outdoor seating is something that we've come to find in the industry, and I think the application only has two tops, maybe 4 seats, maybe 6 total outside. So it's not to have a large seating section, it's more, it helps bring people into the establishment, and it also keeps the neighborhood, frankly, a little safer, because there's people sitting outside kind of watching the street in all hours of the evening.
Yeah, I think our interest of a number of these businesses and the residents, in fact, of Old Goucher is to bring a lot more foot traffic and different foot traffic even. It's pretty accessible by public transportation and, you know, other neighborhoods, Charles Village and Mount Vernon, et cetera, just for pedestrians. And we kind of want the whole neighborhood to sort of rise up and be a place where people are meeting on the street and socializing and, you know, helping all of these businesses in the area flourish. So that's our goal.
Mr. Baumgartner, would you mind addressing the issue of the outdoor seating and what requirements, if any, or prohibitions there are in this particular?
In the C1 district, outdoor dining is allowed by right. So technically speaking, you can have outdoor dining with nothing else in the building. So it would be allowed by right.
But outdoor dining must be accessory to a restaurant or carry-out food shop, neither of which is proposed by this applicant.
Got it.
So close.
Yeah.
That's all like, wait, what?
Premises as a tavern.
We are offering food. It isn't a restaurant. Food's going to be very much an accessory to the use. I mean, arguably, it's a restaurant a little bit.
Now, my understanding of the code is that there are different definitions of tavern and restaurant, which I guess is why one's called a tavern and one's called a restaurant. Okay. We understand your request, and we understand there's some nuances in the code. Any other questions from the board?
Yes. Since you're requesting outdoor seating, this says that your proposed hours are from 10:30 in the morning to 2 a.m.
Correct.
So is the proposed seating also until 2 o'clock in the
No,
morning?
the outdoor seating would be cut off probably closer to midnight or 1, depending on the time of the week. I would imagine during the week, it would be prior to midnight, and weekends, maybe 1. We'd be monitoring the volume levels from those seats very closely. One thing that we're trying to do, and it's great working so closely with Kelly in the Old Goucher District, is that Kelly has his cell phone number, and he has Kelly's. And Kelly also has my cell phone number. So if there were ever to be a problem in any capacity, and we can't ever say that there would never be an issue,
Sure.
we can always communicate and address it very, very quickly. This is a small place, so in terms of staffing, it should be minimal. So Mr. Rainier, again, who lives 4 blocks away, 5 blocks away, you know, there's always ability for him to address an issue if it comes up.
Mr. Chairman and members of the board, just to clarify, this would be a question for the zoning administrator, but outdoor dining itself is allowed by right in the C1 district. So that use in and of itself is allowed by right. The ability to have outdoor dining as accessory to a restaurant, that would be the conditional use, and I understand that with the distinction between tavern and restaurant, but alone, outdoor dining is allowed by right. So as long as the zoning administrator would approve that use, it wouldn't have to be accessory to a restaurant or tavern. It would be allowed under its own right.
Excellent.
Unless Mr. French has a distinction that he can point out to me. But again, I would leave that to the zoning administrator's office to address.
Okay. All right. Thank you.
Thank
for
you.
your presentation.
May we be excused?
You may be.
Thank you very much.
Good luck to you.
Thank you.
Okay, now we start back to 248. Taking it back to the top, 2019-248, 3401 East Federal Street. Talon Lloyd. Good afternoon.
Afternoon.
Are you Mr. Lloyd?
I am.
Okay.
I am.
Don't have anyone else here for you? Okay. This is a request to use portion of the premises as an adult daycare center with community center and headquarters office. Is that correct?
That's correct.
Okay. We swear the parties, please. Witnesses.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yeah, I do.
Are you the opposition?
No, ma'am.
Oh, okay.
I'm on this side.
Oh, okay. Just, I'm like, usually you're, okay.
He's applying for a billboard license.
Well, that's going to take some time. So. Okay. Do we have any staff reports?
Yes, thank you. Planning Department reviewed this application, noted that 3401 East Federal Street is zoned I-2, an industrial zone, which does not allow community centers as either a permitted or a conditional use. It does allow daycare centers, adult or child, as permitted uses only when accessory to an office structure, research and development facility, or industrial use, and integrated into that structure, facility, or use to serve its employees. This particular application, the department recommends disapproval of unless the applicant demonstrates that if it is an industrial use, that the proposed daycare center, adult daycare center, would also be serving only the employees of the applicant's industrial site. Thank you.
Okay. Mr. Lloyd, having heard from planning, what can you tell us about your project and how you can meet those standards?
I suppose we could meet standards by removing a community development center from there and calling it an adult daycare with the accessory to the headquarters of the owning LLC's business.
Okay, and would that daycare center solely cater to the employees of that business? Or would it be a standalone daycare center to the community at large? And bear with me, Mr. French, is that the distinction you're making, or that planning has made?
The zoning code specifically states that the daycare center, whether it's an adult or child daycare center, is permitted only when accessory to an office structure, a research and development facility, or an industrial use, and integrated into that structure, facility, or use to serve its employees. And therefore, it's incumbent upon the applicant to show how the proposed use would be basically serving only the employees of an industrial use of this property. And therefore, there needs to be an industrial use established first. And an LLC that isn't an industrial use would not necessarily qualify.
The board in your staff report has the language of 11101, including the table language, and not to disagree with my colleague, but the language says only when accessory to an office structure, comma, research and development facility, comma, or industrial use. So there's 3 separate types of uses you can make out of the property. And then it says and integrated into that structure, facility, or use to serve its employees. The word only is not in there. The word exclusive to its employees is not in there. And the planning department can certainly recommend that the board read the provision that way. But it would be up for the board to determine if the intent of this definition is to restrict the use to only the employees of that office or industrial use or research and development facility or not.
I believe in my initial discussions with Mr. Derrick here, an adult daycare is permitted by right. However, there is a clause with that that says it can only be an accessory use or an accessory to, right,
Joe Richards,
office use.
Joe Richards for the record. Globe Family Support Center is that secondary entity, and that's focused on brightening the lives of individuals and seniors with disabilities. The daycare itself is adult medical, and that would bring at least 45 jobs in the community. It will also service all those seniors in the surrounding communities. Orangeville, Fort Worthington, Bel Air, Addison, Orchard Ridge. This program is very important for the seniors because a lot of those seniors in the area doesn't have anything to do. This program is a free program, and to give them something to do. And when seniors have something to do, that eliminates the onset, possibly, of Alzheimer's or dementia or anything similar thereof.
What kind of activities will be taking place in the community center?
Christine David for the record.
Okay, step up to the mic.
Oh, well,
Okay.
you said community center.
Yes.
Okay, I have a letter I'd like to introduce submit to the panel from Fort Worth Neighborhood Association. They will be using the building as their community association, in addition to Bel Air Addison Community Association, Orangeville Community Association, Broadway East Community Association. So all those associations are wrapped around this entity for the support of the seniors.
Okay, you said you have a letter?
Yeah, I have a letter submit from Fort Worth Neighborhood Association. Delegate Stephanie Smith, 45th Legislative District. Corey McCray, Senator, Legislative District 45th. And City Council President Brandon Scott.
Well, we have, just put this out there for you to consider.
Okay.
The establishment of a community center here would not be allowed under particular zoning.
Okay, the community center is in conjunction with.
Well, wait a minute, so the adult daycare center, my understanding was that was the secondary part that was adjacent to something else.
Okay.
So it has to be a primary thing.
Right, the adult daycare center is adjacent to a Globe Family Support Center. The community will use the building when the daycare is not there.
When it's closed.
When it's
It's
closed.
not essentially a community development center, it's just they're utilizing the building for their own purposes.
I'm confused. What's the principal use?
Yeah, there we go. Adult daycare.
A Globe Family Support
Globe
Group
Family
LLC.
Support Center, LLC.
What's that?
Okay, we focus on working with seniors and individuals with disabilities. We help them with ADLs, active daily care of living. We help them with literacy. We help them with getting resources that they may need to live a positive life. Medical services, clinical services, social work services.
Chairman, may I, real quick?
One second. I think you might have mentioned your name, but I don't know if we're getting it when you're speaking.
Oh, I'm
Can you
sorry,
say it again?
Christine David.
And you're affiliated
I
with what?
actually am the compliance and coordinator for regulations in the facility with the group, and I oversee the clinical side of it.
Of the adult daycare
Adult
center.
daycares,
Medical
yes.
daycare, right.
You're saying adult medical
You're adding medical, and that's
Are you
not
providing
here.
medication to the clients who will be there?
Yes.
And what kind of what's your spectrum of adults with disabilities who need to be there? What levels are we talking about? Level 1, level 2, level 3?
So we are servicing all 3 levels. We are actually level 1, 2, and 3. So we have people with disabilities and people that are cognitively disabled too, as well as people that are independent. So we are trying to focus activities on to those type of zones where we can help each one individually. So.
And do you have adult medical daycares, any other adult medical daycare centers being operated now in the city?
Yes.
Not in the city, in the county.
In the county.
In the county,
yes.
okay.
And Mr. Chairman, if I can make a distinction, a community center has a very defined definition in the zoning code. If you have a business that has an empty conference room that you from time to time let folks use, that would not be a community center. That's simply a space that you let folks use. So I think we're getting a little bit confused there. A community center is just flat out not allowed in the zoning district. So that would be a non-starter.
Thank you.
But I hope that clarifies.
It does.
Thank you
It
for the
does.
clear up.
So do I take it from your presentation thus far that you're not intending to operate a community center per se?
Right.
You're intending to utilize space for
Right.
benefit of the community at
Yes.
large?
Exactly.
Okay.
One at a time, please, just make it difficult for the transcript. Thank you.
Go ahead, sir, I'm sorry.
So I'm Mike Hilliard, I'm the Community Services Director of the Hardbell Community Organization, which acts as an umbrella over 37 communities in Northeast Baltimore, including Bel Air Edison. The Bel Air Edison Community Association is adjacent to this property. They are in support of this use as they feel their seniors can take advantage of it. And The other thing I would say is, it's my understanding that this use will be an accessory, I don't want to use the term primary because I'll get myself in trouble with Mr. French. The accessory use is adult daycare. The adult daycare center will make space available to community associations for meetings. So it won't specifically be used as a community center as defined in the zoning code.
So, again, the adult daycare center is the accessory
Correct.
Right.
to,
A Glow Family Support Center.
So are you moving your entire headquarters into this building?
Yes.
So a Glow will now be in Baltimore City.
Right.
And secondary use is having the adult medical daycare center in the building.
Absolutely.
And then also allowing neighboring community associations to use the facility when it's not being used for adult medical daycare.
Correct.
Or a Glow.
Or a Glow event, okay. Okay.
How many other Aglows are there?
One.
Okay, so this would just be the second one?
This will be the one. A Glow is the parent company, so it'll just be one.
Okay, but the location you have right now in Catonsville, Woodlawn, whatever it is, 21244, is that where it's located right now?
Yes.
The facility in the county, would that remain open?
No, not the Glow. A Glow
Not
will
as
be
a Glow?
no, not Glow will be moving into Federal Street.
Okay, would that remain open as an adult daycare?
Yes.
Okay.
okay, I think that satisfies it. So, bear with me, Mr. Baumgartner. If what is proposed is the new headquarters of the entity, with the adult daycare medical center.
Adult medical daycare. It's different from adult daycare.
Yeah, I'm reading what's on what's presented to me here, which simply says adult daycare, which is
Okay.
probably where we got off on the wrong foot, maybe. Adult medical daycare. And as an accessory, I think that suggests that it's lesser involved than the original primary use. So you have the headquarters for the entity. This daycare center, is it gonna be, how many days a week will it be open?
5, Monday through Friday.
Monday through Friday. Will the hours of the daycare extend past the hours of the headquarters of the building?
No.
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 How many employees will be there in the headquarters function?
1, 2, 3, maybe 16 to 18.
And that includes staff for the adult medical daycare?
No.
Okay, so that's in addition
separate,
to,
yeah.
that's separate,
That's
okay.
And how many employees do you envision for the adult medical daycare?
We think that once it's up and licenses is given 40.
40 employees?
Yeah.
Which is what would follow under the code for the adult daycare as the permitted use, and then the accessory office or headquarters.
So we need to switch
If it were the reverse, the board would not have the authority to approve the application because the office would have to be accessory to a primary industrial use. And I don't think an adult daycare would be an industrial use. So if and the difference between principal and accessory becomes the square footage, number of employees, the revenue from the business, things of that nature. So if the square footage of the building, for example, for the adult daycare or the adult medical daycare was more than the office, if there were more employees for the daycare than the office, that would all contribute to the daycare being the primary use of the structure, and then the office being accessory to that use.
I believe we proposed approximately 6,000, it's a 10,300 square foot building. We proposed around 6,000 square foot of that being the Aglow family the headquarters to Aglow, and then approximately 4,000 being allocated towards the adult medical daycare, but there is an overlap in space as well. There's shared common space, common areas as well.
Okay.
I'm confused. What's the principal use? What is
Under the
principal
code, the
use?
board is,
Headquarters.
Under,
Headquarters for Glow Family Support Center.
under the code, the primary use would have to be the daycare, and everything else would have to be accessory under the daycare. That, the board would have the authority to approve that.
We don't have the authority to approve an office
As the primary.
as the primary with the adult medical daycare as the secondary. Okay.
So, as presented, it looks like we don't have the authority to approve that under the current code, because, well, wait a minute. You presented it as premises as the adult, now medical daycare center. You said with community center and headquarters office. Is it your presentation that the adult medical daycare is the primary use with an adjacent or accessory use as headquarters for the entity?
Yes, that would be correct.
Okay. Is that clear on the record? Okay.
Sounds like we got there. Sounds like we got there.
Okay. All right. Is there anything else you'd like to add to your application? No? All right. Thank you so much for your presentation.
Thank you.
Good luck.
Thank you.
Thank you, Mr. Baumgartner, for that clarification. Okay, calling the case 2019-350, 102 East 20th Street, Sam Gherkin. That's tough. Good afternoon, Mr. Gherkin. How are you? This is a request to continue use as a 3 dwelling unit. Is that correct? Okay. Could we swear the witness?
Raise your right hand, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes. Do we have any staff reports?
Yes, Planning Department has reviewed this application, noted that this property was previously used as a multifamily dwelling, and has no objection to the application. Thank you.
Okay. Tell us about your project, Mr. Gherkin.
It's already set up as a current 3-unit project. It's a full renovation. It's a complete renovation. All units is, everything new, HVAC, plumbing, electrical, windows, roof, everything.
All right. Which of the, let's see, which of the premises on this photo is?
Second one from in. Yes, sir.
This one here?
Yes, sir.
Got it. Okay. All right. Let's see. Do we have an issue on this one, Mr. Gherkin, with conducting some work without some permits at some point?
Not from us, no.
Is that the wrong thing? Let's see.
Looks like there's a work without a permit issued, I don't have a date here, but in 2019.
All the mechanicals and stuff. Yeah.
So as far as you know, everything you've done is
Yeah, I
permitted?
haven't received anything, no, sir.
Okay. And what's your role with regard to the project?
I am a contractor.
Okay. Any questions from the board? No.
Nope, none.
All right. Mr. Gherkin, thanks for your presentation.
Thank you so
Good luck
much.
to you. Calling the case of 2019-352, 2641 Ashland Avenue, Andrea and Courtney Randall. Good afternoon, Ms. Randall.
Hello,
How are you?
just fine, thanks.
All right, this is a request to use the entire premises as offices, is that right?
Yes,
Mrs. Randall, are you?
I'm Andrea.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do. Yes,
Do we have any staff reports?
Yes, Planning Department has reviewed this application, noted that the property qualifies for approval as a neighborhood commercial establishment, and has no objection to the application. Thank you.
Okay. Ms. Randall, tell us about your project.
I just basically want to use it as office spaces, one for myself, and then I'll potentially rent the others out to other people who need office spaces.
Okay, and what how will you utilize the office space?
So my personal office I will use for my personal practice, but I go out to see my clients or I go out to see other individuals in the community. I'm a
And you were
licensed
here-
therapist.
Therapist, okay.
Yes,
Mental health?
yes.
Okay, all right. Upstairs portion.
And I brought the pictures I was supposed to bring about the door, so you can see that the whole building is one building once you're inside.
Yes, so I know we had requested you supplement sort of a record with some additional information. All right.
So,
Tell us what it is we're looking at.
So there are pictures from the, if you go in, so downstairs there's a side door and a front door. So if you go in, there's a door that leads you to the upstairs of the building. So that's the door from downstairs to upstairs. And that's like once the door is open, like the downstairs portion.
This door is the downstairs door,
Yes.
okay? Mr. Baumgartner, can you help me out with this for a sec?
Sure.
We had requested that this applicant provide additional information for what purpose exactly?
Sure. So this was a neighborhood commercial establishment request. The ground floor had a long-time commercial use, so that part of the property wasn't at issue. The request was to use the second floor as offices.
Yes.
At the last hearing, the testimony was that the second floor had, for a long time, been used as storage space and kind of other uses in conjunction with the ground floor commercial space. So the property had qualified for neighborhood commercial. The only question we had last hearing was the office space in conjunction with a kind of a mental health therapy practice, if it would be used as a medical office or if it would be used as merely an office, an administrative business office for a professional that would then go out into the field, into people's homes. As long as the board is satisfied that the office use will be merely that, will be an office use, and that patients will not be treated in that second floor, the board would have the authority to approve as a neighborhood commercial establishment as a conditional use.
Okay. Is that your intent, Ms. Randall?
Yes.
The offices will be on the first floor and the second floor?
Yes.
Any additional questions from the board?
Nope.
Anything else you'd like to add? Very well. Thank you for your presentation.
You're welcome. Thank you.
Okay, case number 2019-379, 6800 Hartford Road. Shadid Mike Anyawu. Oh, yeah, right. Mr. Anyawu? Yes, sir. Okay, good afternoon. This is a request to use the premises as a hand car wash. Is that correct?
Yes, sir.
Can we swear the witness, please?
Raise your right hand, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
And do we have any staff reports?
We have a letter from Harbell dated November 13th. Mr. Hilliard is here. He will probably go into the details.
Planning Department reviewed this application, noted that this property is located in the C2 zoning district, which does not allow car washes. The department therefore recommends disapproval of the application because the zoning code does not authorize creation of new non-conforming uses, which the proposed hand car wash would be in the C2 zoning district where this property is located. Thank you.
Thank you, Mr. French. Mr. Anyawu, having heard from planning, you're aware, well, you are now certainly from that information, that in a C2 district, car washes are not allowed. So how is it that, what can you tell us to suggest that you should have a car wash or you should be allowed to have a car wash here?
Yeah, I was already aware of that, and
Can you talk a little louder? I'm sorry.
I was already aware of that. That's why I'm just applying for a conditional report. My office is just around the corner. My office at right now is at 8304 Hartford Road. I've been there for like 17 months. So
Wait a minute. Right now, that's why you're applying for what?
no, I said I already currently located at 8304 Hartford Road. That's where my office is right now. And I'm also a dealer at Mayhem and a registered salesman at MVA. So I normally wash my cars 7 miles away most of the time that I bring my car. So I'm just here to appeal in a way to ask, not that I don't know what he's talking about. I'm trying to see if that can be possible. Then I'll really appreciate that.
Well, you have a, first of all, I'm not sure I understand what you said, because what it is you're trying to convey to me. in terms of what it is you're trying to do. Your application indicates you're seeking to have a hand car wash. Are you changing that?
No, sir.
Okay, well, because I think the answer is very simple. You're not allowed to have a car wash in this particular district by virtue of the language of the code. That's prohibited, and we don't have the authority or the discretion, certainly not even the authority, to grant that request at this location. And I guess I'm asking for your response to that, which is what?
That's something that I'm saying. I don't know if there's a way they can do the conditional reports, conditional for now. That I don't know. I don't know how it works. This is my first time of trying to open this
Okay.
kind of business. So,
Well,
Let me try to understand this. What is your business actually?
my business, I'm a wholesale dealer with.
Okay, you're a
Yes,
dealer.
I am a
Okay.
wholesale dealer.
wholesale dealer of what?
Cars.
Okay.
And so you wanted to open up a space to wash the cars that you sell.
Yes, and also wash for people that wants to wash with me.
So you want to operate a car wash?
Yes, sir.
Okay.
Okay. You can't do that here. That's the nature of the code at this particular location. So, and I think anything else that you might be requesting would have to be subject to a different application. Because I don't know if there's a way to modify this one to get you anywhere or get the approval that you seek for this, unless we're talking about a different location. Because in that district, which this address is, in C2, the code prohibits that use.
So we can't, you're saying you wanted a conditional use, we can't grant that because the code does not allow a car wash at all.
Under any circumstance.
I really appreciate it.
Okay,
Okay.
thank you, sir.
Yeah, thank you.
Thank you, Mr. Hilliard.
I would have said just what you, Mr. French and Commissioner Middleton.
Very well. Case number 2019-380, 4227 Springwood Avenue. Adele Fry? I could be wrong. Adele,
Adele.
last name?
Elfrey.
L free.
The L is missing
The L
on
is
the.
missing.
Okay.
Okay.
It's supposed to
I
be-
apologize because, sometimes we don't have all the letters and
No,
so
it's
I
okay.
apologize for. And this, Mr. Elfrey is, a request to continue to use a portion known as 6010 Marluth Avenue as an auto repair shop in such a way that will exceed limitations imposed by, this was a prior, I guess, ruling BMZA 344-73X, which was a prior authorization to utilize this space with a total of 4 cars.
Correct.
Okay,
From 1975. It's
so
really-
1975, way back in the day. Okay, can we swear the parties, please?
Yes, right. Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, and before we get the staff reports, Mr. Hilliard, you're on the side of the applicant today? Okay, so we have no.
College for being a switch guy.
That's all right, that's all right, that's no problem. Can we get staff reports if we have it?
Yes, we have the letter from Harbell supporting the request. It's dated November 13th.
Planning Department reviewed this application, noted that this property is in the R3 residential zoning district. Its current operation is a non-conforming use, which was authorized by the board, as you've heard, by the decision in Appeal Number 344-73X. As part of the approval of that particular application, the board specified a maximum of 4 automobiles being stored for work on the site at any one time. The applicant is requesting that this maximum number be raised to 15 vehicles. And the zoning administrator has basically determined this would constitute expansion of existing non-conforming use of the property, and the zoning code in section 18302 prohibits expansion of a non-conforming use in any manner. The Department of Planning therefore recommends disapproval of the application because the zoning code does not authorize the board to approve expansion of a non-conforming use, which the existing use at its current location is in the R3 zoning district. Thank you.
Okay. So, Mr. Elfrey, having heard from planning, tell us how you can reconcile what the code says to what it is you'd like to do.
I know that for something that's grandfathered in, it's hard. If it's not conforming, you can't really change it. But it's a law from 1975. We're trying to earn a living, and storing 4 vehicles just doesn't work. We can't make it work. We have a lot in the back that's locked with tall fence.
Yes, sir.
That can store up to 15, 20 vehicles. We're asking up to 15. If we can get 10 vehicles granted, we can make that work. But everything else stays the same. We're just asking for more, availability to store more vehicles so we can conduct our business.
And you're operating as an auto repair shop, right?
Correct.
And you're permitted 4 cars on the site right now?
Yes, from a 1975
From
permit.
this photograph, I'm looking at 1, 2, 3, 4, 5, 6, 7, 8,
And a school bus.
and whatever that other thing
The
is.
school bus is the neighbor's, that's not ours.
It's on your neighbor's property?
The school bus is, yes. That's not us.
Okay.
Do you guys have the site plan that I submitted with my application?
Under the prior zoning code,
Yes.
the board had the discretion to grant expansions for non-conforming uses to up to 25%. Under the current code, that discretion was taken away. So the code is pretty clear that for a non-conforming use or a non-complying structure, the board has no authority to expand at non-conforming use. So the code is what the code is. And if there's anything else that you could offer about the type of use you have or how you've operated, that would certainly be relevant to the board. But it's just that under the prior code, there was some flexibility to expand. And under the current code, that was specifically taken away.
Yeah, so obviously, as Mr. Baumgartner just mentioned, it limits our authority to assist you in this situation. I mean, I recognize clearly the need for space when you're operating an auto repair shop, to be able to, because you can't work on all the vehicles at one time, and you got to have somewhere so they can get to you and you can get them back. But unfortunately, in 2017, when the code changed, so did our authority or discretion to grant you what would seem like something reasonable to do. Do you operate any other locations? Your auto repair shop in any other locations?
No, but as you'll see in the next one, we plan on expanding, and we'll get into that in the next one.
Okay.
When did you acquire this business?
2014, so we've been here over 5 years now in this exact location.
And when you acquired it in 2014, did you know that of the restriction that you could only have 4 cars?
I did not know of that exact number, and when I tried applying for my use permit in 14, and you can see I started but never finished it, I was told that the owner of the building, I have a landlord, is supposed to submit the use, but now I'm learning whoever is using the property has to submit it. So now I'm doing this 5 years late, and I'm just trying to just do everything by the rules, by the book.
Okay.
We appreciate
We've
that.
been operating here for 5 years, and 4 cars, we just cannot make that work.
Yeah.
And I have a question. Those 4 cars, is that outside only? Because I have a front garage and a rear garage that can fit 2 each. It doesn't really specify in the permit.
I've not seen the ruling or the condition. At least since I've been on the board, we tend to focus on what's sitting outside so that people can see.
Right. I mean, even if I keep everything locked in the back, you won't see anything when my gate is closed. But
Yeah. I think we're left with.
it's kind of like inflation, $1 in 1975 was different. It's different than today.
Well, sure.
So working with 4 cars we have a big following.
It's not, this literally, the note we have is condition of not having more than 4 customer cars on premises. So I read that as you get 4 cars
On total.
Right, that's clear enough.
I'd like to hear why Hartwell supports this.
So, as he said, they've been in operation since 2014. They've had a good relationship with the Sedmont Improvement Community Association. They've found them to be a good neighbor, and that's why Sedmont, and in turn Harbell, is supporting this.
And the surrounding neighbors
We
support
have
this?
one right here.
I'm one.
There was one.
You came here as opposition? or-
My name is Walker Terrett. I'm here in opposition.
Okay, and you are in opposition?
I am.
Okay.
You gotta be on this side.
Oh, I'm sorry. I didn't
One at
realize.
a time here, because we're getting a little crazy. What's your name?
Walker Terrett.
How do you spell Terrett?
T-E-R-E-T.
Thank you.
It's a mood issue. Go ahead, Mr. Terry. You spent the time, came down.
Yeah, and I spoke with these gentlemen out in the hall, and I have to say that I respect what they're trying to do, and they were very open to addressing any of my specific concerns. But I have to still remain in opposition because it's their landlord who continually keeps renting this property to different auto mechanics, and the next group might not be as nice as them. I mean, I've asked for quieter music, I've asked for not working as late, and these guys have said okay, but then the previous people were far worse, and the next person could be too. I think it's an inappropriate use of the land. It's otherwise a very quiet neighborhood. There's city neighbors, a school with small children just up the street, and with the mechanic shop, there's routinely shouting matches with profanities and this and that, and it's just not.
Where do you live?
I live on Springwood Avenue, 4307.
So if I show you this map, can you like rotate it till you show me how far away you live? I can rotate it for you.
Is that oh yeah, keep going. So my property's next door to this one.
Oh, okay, so you're just up at that corner.
house.
Okay, thank you.
Where's it?
Up the corner, one house in.
So their official address is on Springwood, but the face of the front of their business is on Marluth, and it faces my next door neighbor's house, basically.
Okay.
And just as a very, very, very brief explanation, the timeline of this makes a lot of sense. So the 1971 code grandfathered in a lot of uses. So this was probably an auto repair shop from probably the 40s or 50s that had just a small imprint, a couple cars that they worked on. And when the code was amended in 1971, this was most likely grandfathered in, and then the board at that time capped it at 4, acknowledging that it had been there for quite some time.
Elected sufficient for the purposes then.
Correct. The board's file on this is in city archives, so I don't have access to that. I was not around in 1973. But the timeline makes sense for a grandfathered use in a residential district, but capping it at a certain number of cars, given its location within an R3 district. But the code is, as I mentioned, the code is the code. It's an R3 district where you can't expand any kind of non-conforming use.
And that certain number of cars is for?
That's correct.
May I ask a question?
Yes, sir.
The grandfathered use, even though the actual owner of the property seems to be relatively absentee, and there's no connection between the different people who have used the property over the years, but the grandfathered use still applies?
Correct. So the use follows the land, not the operator.
Okay.
So as long as the use does not lapse for more than 12 months, that use can continue.
And if it did lapse for more than 12 months?
You would have to notify the city zoning department, and then they would put a note in the system as to when that use lapsed. And then they would not get a new use and occupancy permit if someone filed for a new one later in time.
Mm-hmm.
But otherwise, the city would simply have no idea that a property was not being used for something,
Right.
Without some notation in the system as to when that property became vacant or unused.
Okay, thank you.
All right, is there anything else you'd like to add with regard to this particular address, Springwood
As
Avenue?
far as the 4 vehicles are involved, is it at least possible to change it to 4 vehicles outside?
Well, we're stuck with the board's.
We can't change anything?
No, we're stuck with, because changing anything would be.
Not conforming use.
Right, which the code prohibits us from doing. So, yeah, I mean,
You can't.
I don't even know, we could say 3. We couldn't go down, certainly couldn't go down to 3. We give you 4. But we can't make any amendments to that.
Okay.
Because we're prohibited from doing so by the code. So that's where we are on that particular case.
All right.
So if nothing else, we'll move on to the next, I'll call the next matter, because that's you as well, right? Case number 2019-381, 5837 Bel Air Road, Adele Elfree. This is a request to raise the existing structure, construct a 1-story building that will be used as an auto repair shop, including body and fender repair. Is that correct, sir?
want to step over onto
Okay.
this side for this case.
Did I read that correctly? That's what you're seeking to do?
Yes.
Okay. Let's swear the parties with regard to this particular matter as well.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Hey, do we have any staff reports for 381?
Yes, we have the adjoining letter from Harbell dated November 13th, signed by Mr. Hilliard. I'm assuming he will make his point. Thank you.
Planning Department reviewed this application, noted that this property is in the C2 zoning district. The C2 zoning district, although it does allow automobile repairs minor, does not allow automobile repairs major, and the applicant is requesting approval of automobile repairs major. For that reason, the Department of Planning recommends disapproval of the application because the zoning code does not authorize creation of new non-conforming uses, which motor vehicle repairs major would be in the C2 zoning district where this property is located. Thank you.
What's the difference between major and minor?
I'll get the code out, or Derek will answer that. Do you want to go, Derek?
Sure. Motor vehicle repair major. An establishment that is engaged in major repairs to motor vehicles, such as engine rebuilding, major reconditioning of worn or damaged motor vehicles or trailers, towing services, collision services, body frame, fender repair, straightening, painting, or similar uses.
Okay. Well, it looks like,
Thank you.
Mr. Alfrey, that you're seeking to establish major auto repair here at this location. Do you own this property?
It's currently owned by the city. We're getting ready to make an offer, but we're working with the Vacants to Value program. It's an abandoned nursing home at the moment. It's been vacant for 20 years.
Okay.
It's half a mile away, isn't it?
Yeah, it's really close.
Yeah.
Okay. Well, unfortunately, again, this particular use is prohibited by the code at this location in this zoning district. I mean, I don't think there's any two ways to cut it. You're seeking to do primary major auto repairs at that location, right?
Yes, specifically, we focus on mechanical work, which is allowed by C2 regulations, but we would like some conditions to be able to do body and fender repair as well. All the neighbors are doing it, but I understand some of them are also grandfathered in.
All right. Well, I think the code's pretty clear. You can't do body and fender. That's part of auto maintenance. Repair
Body
major.
fender's part of C4.
So before the property before 2017, it was Zone B3, which would have allowed motor vehicle repair major. In 2017, it switched over to C2, which took away the right to use it for motor vehicle repair major. Within minor, just if this helps, repair or replacement of cooling, electrical, fuel, and exhaust systems, brake adjustments, relining and repairs, wheel alignment, balancing and servicing, repair and replacement of shock absorbers, and replacement or adjustment of mufflers, tailpipes, hoses, belts, light bulbs, fuses, windshield wipers, grease retainers, and wheel bearings. So all of that would be auto.
Like a Firestone.
Yeah, like a
It's
tire
it's
care
Firestone,
center or Midas, Meineke. Okay.
And by the way, everything will be indoors. We're raising the building, building a state-of-the-art building. It's going to be a warehouse type. It's going to be about 20 feet high, and everything will be indoors. Everything.
Well, the issue is what is the everything? And
Mechanical, body, and paint.
okay,
That's it.
but as we just said, cannot be body, fender,
Even if
and
it's
certain
inside.
mechanical. I mean, we've read the portions of the code. What you're seeking to do is operate a full-service auto repair shop, and that is prohibited in that district since 2017.
Why did it change in 2017?
The city council made a change to the code. There were amendments. It was how many years, I don't know, prior to things becoming enacted?
6 years.
Yeah, I mean, it was an old code. It was last changed prior to that, since, what, 1971?
Correct.
So it was time for a change to comport with 2019, 20th century, the 2010s and the whatever, and here we are. Unfortunately, these items that you want to do in these locations are things that were addressed specifically by the code. So I think you're about 2 years late to get it in.
Yeah.
But I would encourage you to If that's what your business in, that's what your
We wanna-
expertise is? in?
Mechanical, but we want to expand and do a one-stop shop, everything in one stop.
Well, I mean, I would also encourage you to talk with, planning and find some areas within the city where some of these things could be located. Unfortunately, these locations are just not gonna be viable for what it is you wanna do under these particular applications, so, we don't have the discretion to grant the relief that it is that you're requesting, here for these locations in these districts.
But we are able to do auto repair minor under C2.
That's correct, by right. So you wouldn't need hearing.
You would even need,
Apply for the use permit.
That's correct.
Exactly, but, of course, staying within the auto repair minor is the key, so that's where it is. All right? Okay, anything else you'd like to add? Well, Mr. Hilliard?
When this initially came up,
Yes, sir.
both the Sedmont Community Improvement Association and Harbell liked it because this property is an abandoned nursing home that is been a chronic problem on Bel Air Road.
Sure.
Unfortunately, as Mr. French, Mr. Baumgartner, and the chairman have pointed out, auto repair major does not conform with that location. But we would welcome it if the appellants were willing to do an auto repair minor facility at that location.
Okay, thank you for that. Anything else, Mr. Alfred?
Is there anything you want to say?
I just want to support them in their effort to move here. It's a much more appropriate location for the work that they're obviously very good at doing, and these guys would be a great addition to the Bel Air Road corridor. And coincidentally, it would solve a lot of the problems from the previous case.
Right. Understood.
Because they would have a more appropriate place to do their work.
Understood. Okay, anything else from the board?
No,
No.
good luck,
Okay.
guys.
Thank you.
Have a
Thank
nice
you.
day.
Appreciate your time.
how many do we have left?
I'm sorry.
2, 3, 4.
Yeah. Yeah, that's right through. Okay, 2019, I'm sorry. 2019-388, 225 East North Avenue, Tacoma Farmer.
I think I'll learn something.
Mr. Farmer? Good afternoon. This is a request to use the first floor as a hair and body art studio.
Actually, I want to do non-surgical hair pigmentation
Wait a minute, let's
studio.
hold on.
I want to swear you in so we can record properly. Raise your right hand. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, and Mr. Farmer, as I mentioned, according to the application that's presented, it states to use first floor as a hair and body art studio. And you are at least seeking to qualify that or amend it to do what?
To do scalp pigmentation, and it's similar to tattooing, but you know what I mean, just on the hairline or different people with scars and whatnot on their head.
Scalp pigmentation?
Scalp
And is that the sole practice that you're going to
Yes,
perform there?
and the barber services that go along with the scalp pigmentation service.
Okay.
Which would be what?
With just blending everything and because the hair still grows, but you have to work around the pigmentation where it may not be any hair.
So it's a barber shop,
It's
effectively, with the addition of the scalp pigmentation services.
I could use that with my 40 stitches.
And do we have any staff reports?
Yes, we have a letter from the West Greymount Community Association. They are in support of the request. They note with pride that the applicant's long history with both this neighborhood and this address, and they wish them success.
Planning Department reviewed this application, noted basically that there are two components to the request that the applicant is making. One is for a hair studio, which is something that could be approved as a personal service establishment under the neighborhood commercial establishment category in the zoning code. The other portion is the body art studio, which is something that is covered in the zoning code as a body art establishment, which is a use that is not authorized under the neighborhood commercial establishment category. And therefore, the Planning Department recommends approval of the portion of the application relating to a hair studio as a type of personal services establishment. The department recommends disapproval of the portion of the application relating to a body art studio, as this is a form of body art establishment, which is a prohibited use in the office residential zoning district where this property is located. And the zoning code does not authorize creation of new nonconforming uses, which a body art establishment would be in the office residential district where the property is located. Thank you.
Okay, Mr. Farmer, having heard from planning, yeah, you've described it a little bit, but
Well,
tell us about your project.
that was the body art was something I was interested in. I mean, me being an artist and having good relationships with a lot of other body artists. But I retract that and I'm gonna stick to hair and that's my specialty. Being a barber for 8 years now, professional barber license, and so I want to stick to the hair. The hair is my specialty, and that's my plan.
And that would include the, what you call it, pigmentation?
Yep, this is the non-surgical scalp pigmentation. Yeah.
Oh, wait a minute. I thought my understanding from maybe what planning's comments were are that pigmentation goes to the body art, which is a non-conforming use, which you cannot be created anew.
I think the applicant would need to explain whether the pigmentation could be somehow accessory to the hair studio function that he is proposing.
Ah, okay. How about that?
That sounds beautiful. Yeah. But yeah, the hair pigmentation, it lasts for 3 to 5 years. It's not permanent. It's really it's under the stature of permanent makeup.
Okay. So your folks come in for hair care.
Hair care.
They determine or seeking, or you determine that they may also need something additional given their particular makeup, such that the body pigmentation may add to their hair care. All right, and okay, but the primary use of your facility is
Barbering
hair
services
salon,
and
barbershop.
hair. Yeah, and hair, scissor cuts and
But
fades.
you'd like to be allowed to be able to provide that
I would like
body scalp pigmentation service if needed.
Yes, because I have been taking several courses, and I would like to use this stuff, but I want to get set up to leave the previous place that I work in and come here and operate my business, and I would like to provide that service if possible.
Do you have to have a separate license to do this non-surgical hair pigmentation?
Well, it's so new at this point in time. It's not really. You can get licensed through the teachers that you go see and the classes that you take, but it's really, I've been doing a lot of research. There's no real license for that service at this point in time.
And so this business that you're proposing, I couldn't come there and get a tattoo on my arm.
No.
Okay. It would merely be, as the chairman mentioned, something accessory to a salon or a barber shop, but it's a specific enhancement for those types of services.
Yes, sir.
Could I get eyelash extensions?
No.
Could I get microblading on my eyebrows?
Yes.
You can see that when new uses come up, we're not always familiar with those new uses are. So it's something that we try to figure out exactly how does that fit into the current code.
I was interested in the tattoo, and I do have a lot of relationship, and I would like to, and that was always something that was interesting to me, but I'm not. That's something that I don't want to. That I'm kind of. The board has told me that that's not available for the space that I have, so I'm gonna stick to stick to what I've been doing. Hopefully I can add the scalp pigmentation as an addition to my barbering services.
Okay. Any other questions from the board?
Nope.
All right, thank you, Mr. Farmer. Appreciate your presentation. Good luck to you, sir.
We did 389 already.
Yeah, okay, 2019-391, 628 South Broadway, Stephen Fogelman.
He's coming.
The last attorney standing. How are you all? It is a pleasure to appear before you for the
Sometimes
first
it's a good thing if
time.
you're still standing.
And sometimes you get your best deal in an empty courtroom. Stephen Fogelman, Councilman, it's a pleasure to see you. Commissioner, a pleasure to see you. You've left your previous board and commission. We miss you dearly, but we're glad to see you here. Thank you. So this is a bar. It's been a liquor store since the day after Prohibition, effectively. And
So you want to continue use as a liquor store, but adding use as a tavern?
yes, and probably the smallest tavern in all of Fells Point. You may be aware, if you've been, I live in Canton, if you've been to Bo Brooks Lighthouse Liquors, if you've been to, what's that one, Canton Crossing Wine and Spirits, if you've been to Bristol Liquors, just a few blocks up, each of them have a small tasting bar that allows them to pour growlers. It also allows patrons to be able to sample beers and sample wines before they buy the whole bottle. So it's been a popular concept. It also, in all transparency, allows them to utilize a BD7 license and thus remain open to the public on Sunday. And I'm sorry, I didn't mean to jump the gun with Mr. French there. Sorry, sir. You get the first word.
It's your appeal, not mine.
Well, thank you for that, clarifying what it is you're seeking to do and the parameters of that. Now we'll ask for staff reports if we have any.
Thank you, yes. Planning Department notes this property is located in the Fells Point Historic District. Therefore, if there would be any exterior changes to this property as a result of approval of this particular application, the applicant would be required to get an authorization to proceed from the Commission for Historical and Architectural Preservation. The department also notes that according to the records available to it, the property 628 South Broadway has not been consolidated with the property 630 South Broadway all these years or decades that the building on the two lots has functioned as a unit. And therefore, the department recommends that approval of this application be subject to these conditions. One, that the lots now known as 628 South Broadway and 630 South Broadway are consolidated. And two, that any exterior changes, including additions, demolitions, alterations, or new signage, are completed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Thank you, Mr. French. Mr. Fogelman, having heard from planning, should we be favorably disposed towards your application? Are those conditions acceptable?
Absolutely. Thank you. And I'm trying to think if there's anything else I wanted to state. The owners or the tenants of the property have been there for a couple of years. They're good operators. They met with both the Fells Point Residents Association and the Fells Point Community Organization, both organizations within a period of 2 weeks. Unfortunately, neither organization had a quorum at that time, which in a way speaks volumes about how this is a non-controversial project, because you get the big meetings when you've got a heavy-duty project going on. So.
Well, thank you, and we look forward to another opportunity opening on Sundays for folks who need to run out to get something during the Ravens game.
That's it. Chairman Fields, Commissioner Middleton as well. Thank you all. Appreciate it.
Thank you. Okay, finally, case number, no, not finally. Sorry about that, I got another page. 2019-393, 230 North Linwood Avenue, Ramona Del Carmen Reyes. Forgot I had another page behind this. Ouch. Good afternoon. Are you Ms. Reyes? Okay, this is a request to use portion of first floor for retail goods establishment and continue beauty shop. Okay, could we swear the witnesses, please?
Yes, raise your right hands. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth? I do.
Okay,
Can you use the microphone, please?
Slide on over if you don't mind. Thank you. Do we have any staff reports?
Yeah, Planning Department reviewed this application, noted that this property was actually fairly recently the subject of the board's consideration for authorization of a personal service establishment, specifically a beauty salon and spa by the same applicant, which was approved by consent on April 23rd of this year. The applicant basically is proposing to diversify the neighborhood commercial establishment use to add a retail goods establishment with no alcoholic beverage sales, which is also allowed under the neighborhood commercial establishment category in the zoning code. The department therefore recommends approval of the application. Thank you.
Okay. Tell us about your project, ma'am.
If I may, my name is Luis Cardona. I'm the Economic Development Officer for the Southeast District, and in conjunction with my colleague, Mr. Dave Garza, also of BDC, we have been shepherding our client through this process, and if it pleases the board, may I translate?
Spell your name, please.
It's LuisCardona. And if I can testify on her behalf and translate, if that pleases the board.
Thank you.
Yep, our client has been, as Mr. French mentioned, operating a hair salon at this location. And what she's essentially seeking to do is to diversify the type of retail goods that she's selling there, which to date have limited to shampoos and other hair-related retail goods. The diversification is for essentially health supplements and vitamins under the Herbalife world, which is a family of health products that includes shakes and teas and basically other wellness goods that tie into her business, but that merited consideration of the board when she came to the BDC to say, how would you assess this and what do you think is the most appropriate way? And so we met with her and consulted with planning to ensure this was something that merited the board's time, and then we shepherded her through the entire process up to this point. But that's essentially what she's looking to do.
That's awesome. That's great.
She already has an existing retail area at the front of the store, which is where the goods would be contained and sold.
Okay.
Your BDC?
Yes, sir. Both myself and my colleague, Mr. Garza.
That's great. Any questions from the board?
No.
Nope. Well, I commend you on your efforts to expand your business. It's a great, I think, wonderful business model for you, to enhance that. I commend you, gentlemen, also for your assistance, and it's exactly what we need in the city, this kind of cooperation and assistance.
It's our job, sir.
Awesome.
Let me just say, she came to us proactively. Normally, it's the other way.
Right. Pulling, kicking and screaming, but you got somebody willing to do some things and looking for the help that the city has available to it. So that's wonderful. Thank you. Congratulations.
Thank you.
Good luck to you. Okay, let's go to 394 we've done. 396. 2019-396. 2656 through 2658 Miles Avenue. Emily Rapp. Good afternoon.
How's it going?
Ms. Rapp? Hi, how are you?
Good.
This is a request to use first floor, to use first floor portion, wait a minute. To use first floor of the portion known as 2658 Miles Avenue as tattoo shop.
Yes.
It's just written funny.
Okay. Thought it was me.
It's
Anyway.
also, it's the first floor of the whole property, which is technically a double wide row home.
Yes, it
Okay,
is.
so the property has the addresses 2656 through 2658 Miles Avenue. Wonderful. Could we swear the parties?
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Do we have any staff reports?
Yes, first we have a letter from GRIA dated November 19th. The Greater Remington Improvement Association writes in support of the application, Fruit Camps, BMZ request for a conditional use at 2658 Miles Avenue. In 2015, GRIA worked with the City Council to rezone the property as well as several other in the neighborhood from residential uses to commercial uses. We are extremely excited to see this great new business fill the property that has been mostly vacant for years. We have a letter from Andre Stone. No indication. Basically, he writes, I wish to register my support that this building was constructed in 1912 and has been used for a variety of commercial uses and will support the redevelopment of the neighborhood. We have a letter from the Remington Neighborhood Alliance. They write, the application for the conditional use at 2656-2658 Miles Avenue accepted. Our invitation to explain their proposal at the Remington Neighborhood Alliance meeting on November 12, 2019. They answered all questions and seemed to be willing to comply with the legal requirements for a zoning appeal and for their proposed tattoo business. In particular, Ms. Rapp demonstrated that she had indeed obtained the written approval from the property owner as required by the code. Joan Floyd for the Remington Neighborhood Alliance.
Planning Department reviewed this application, noted that this property is in the C1 zoning district where the proposed use is a conditional use. The department has no objection to this application. Thank you.
Thank you, Mr. French. Tell us about your project.
Essentially, we're hoping to start a tattoo shop to house both of our practices. We're both tattoo artists. I am coming from Massachusetts. I used to live in the area, and so I'm going to be coming down with a license that I had there, applying for a license in Baltimore City, and starting up a tattoo shop that will be for the both of us.
Okay. Your name, ma'am?
My name's Georgia McCandlish.
Okay. Are you licensed to? Sorry.
No, you gotta spell it. MCCANDLISH. So I've been living in Maryland and in Baltimore for the last 5 years, and Maryland and Baltimore don't license individuals. They license spaces through the use and occupancy permit. So my work practice has been mostly traveling to other cities to guest spot at licensed tattoo shops. We both have compliances with different types of licensing requirements in different states, including bloodborne pathogen certification and first aid and CPR.
Okay.
Mm-hmm. Yeah.
So now you need a space.
Now we need a space.
We're
We're really excited about Remington.
Okay. Wonderful. Any questions from the board?
Welcome back to Baltimore.
Thank you. I'm excited to be back.
I have a question.
Yeah.
The tattoo that I'm observing,
Yes.
obviously someone else did that for you.
Yes.
Okay.
My mentor did it
I just
for
wanted
me.
to see where your skill set.
Yes.
Do you do microblading?
We do not do microblading.
I really want to know the difference, so I'll just ask everyone who comes up here if they do
Yeah,
microblading.
I do know the difference.
Yeah.
That I can't explain it, but it's not a service that we're offering.
Gotcha.
Mm-hmm. Yeah. So
Thank you.
get up with us after.
Thank you so much, ladies.
Thank you so much.
Okay, good luck to you.
Thank you.
Okay, that was an easy one. Okay, now we think we're at the end. Case number 2019-397, 1804 Harlem Avenue, Daniel Purdy. Well, it was the last one on the docket. So. Good afternoon, Mr. Purdy.
Good afternoon.
Okay, we have this as a request to use first floor as a health and wellness store with one dwelling unit on the second floor. Is that correct, sir?
That is correct, sir.
Okay. We swear the parties, please.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Do we have any staff reports?
Yes, Planning Department reviewed this application, noted that this property is in the Harlem Park 2 urban renewal area, which the urban renewal plan for does not prohibit or further restrict this proposed use. The particular building is eligible for consideration as a neighborhood commercial establishment site, and the department therefore recommends approval of the application. Thank you.
Thank you, Mr. French. Can you tell us about your project, sir?
My wife.
All right. Your name, ma'am?
Cynthia McLean Purdy.
Is she the boss?
Yes.
Well, it's on record now, so.
Thanks. Our project is microblading. No, I'm just kidding. We propose to open, a wellness center on the first floor, reestablishing commercial use at the property. We would like to sell and serve juice products, teas, herbs, aromatherapy. Did I cover everything?
Candles.
Yeah, that's aromatherapy, essential oils, alternative health products for holistic wellness. And on the second floor, we would like to have a one-unit apartment dwelling.
Okay.
Are you gonna live in that second floor? Or
I am not.
rent it out?
We will rent it out.
If the property is through the vacancy value program,
Mm-hmm.
and as far as we know, we would be the first health and wellness establishment in West Baltimore proper. That's on purpose, given the state of the community there, the food deserts and everything else.
Mm-hmm.
bring something positive to the community and be able to serve the people of West Baltimore.
And in your plan, there's a line between, I guess, the front of the building and then in the back on this first floor where it says CBD dispensary. Is this two different rooms?
Well,
Or is it all one open space?
it's all one floor. It's separated by doors.
Okay.
And that particular drawing should have been updated.
Okay, so this is old.
Yes.
Okay, that's fine.
Do you still intend to have the dispensary and selling the CBD products on the
Yes,
first level?
it's a part of the alternative holistic wellness piece of the property.
Do you have a newer drawing that you'd like to submit to supplement your application?
See if I have one. If not, I could definitely get one to you.
Is the sale of the
That's the site
CBD
plan.
goods, is that the primary driver of the business, or is it just one component of?
I'm sorry, I didn't hear the beginning
Sure,
of your
I'm sorry.
question.
Is the sale of CBD products, is that the primary driver of the business, or is just one aspect?
It's just one aspect. It's actually about the aromatherapy and the juice bar, the raw snacks. There's a school across the street. As he mentioned, it's a food desert. It's in the middle of West Baltimore, Southwest Baltimore, where there are only carryouts for chicken and fish and fried food. So we wanted to be able to offer healthier choices to the community. And also, we would like to have open the space to the community for community association meetings, perhaps yoga, meditation, all within the line of health and wellness services.
Okay, thank you.
Thank you.
Just for the record, Mr. Baumgartner
Yes,
just
sir.
handed up another drawing, and I just put a date of 11/19/19 on top. to
Perfect.
indicate we got it today. Today's 19, yes. Okay, is there anything else you'd like to add to your application?
Not if you don't have
All
any
right, any
questions.
more questions from the board?
Good
None.
work.
You answered my one question.
Thank you so much.
Okay, right.
Thank you for your time.
Thank you. Thank you for your patience.
Thank you. Well,
Okay.
it was worth the wait.
I'm just choosing the microblading down the street.
I still don't know what microblading is.
I literally will never need it.
Oh, it's tattooing?
So I will,
Tattoo.
I will never need it. My eyebrows are too thick. It's when you paint.
So why not
my
just call
be-
it
my best friend, she
tattooing?
got it because she picked her eyebrows to death. She didn't have eyebrows.
Any eyebrows?
Yeah, that's Holler